Welcome to the Wednesday, July 6, 2011 meeting of the Municipality of Anchorage Platting Board. Will the Secretary please call the roll?
Lendell Story.
Here.
Steve Abel.
Here.
Ken Fuller. Ellen McKay.
Here.
Anastasia Taylor. Jody Moses.
Here.
Daniel Young.
Present.
Brent Cole. Amy McKenzie. Here.
We do have a quorum, and so we will move on. The first order of business is approval of action summaries. We have action summaries for Wednesday, June 1st, 2011, and Monday, June 6th, 2011. May I have a positive motion, please? Mr. Young, is there a second? Mr. Story, is there any objection to approval of the action summaries? Seeing none, the action summaries are approved, and we'll move on to approval of minutes. We have minutes for Wednesday, June 1st, 2011, and have a positive motion for approval of the minutes. Mr. Young, is there a second? Mr. Story, is there any objection, any corrections to the minutes? Or is there any objection to approval of the minutes? Seeing none, the minutes are approved, and we'll move on to special order of business. Are there any disclosures this evening for the cases involved? Mr. Young.
In the case of S10496-5 and S10625-11 Eagle Crossing subdivision, I worked for the developer on this property in the capacity of stormwater management. I have ongoing business relationships with the presenter, including financial interest, and I declare a conflict of interest and ask to be excused from presiding over this matter.
May I have a motion directing Mr. Young to participate, please? I don't know how that's going to work. Mr. Story.
As before, it appears that Mr. Young does have a conflict with his chief. It doesn't have. As before, it appears that Mr. Young does have a conflict with this case, and I move to direct Mr. Young to participate.
Is there a second? Mr. Cole seconds, and you've already spoken to your motion. Is there any other discussion about Mr. Young's participation? Ms. Moses? No? Is there is objection, so we'll have to vote. Yes means he participates. No means he does not. Okay, Mr. Young, you are directed not to participate in the first cases. Are there any other disclosures? Mr. Young.
In the case of S11850-1 Powder Ridge tracks, my firm has worked for the petitioner in the past. My firm also worked for the petitioner's representative in the past. We have no ongoing work with the petitioner's representative. I have no financial or personal interest in the matters before the board. I can remain impartial, in fact, in action as a member of the board without personal bias. Excuse me. My past involvement and personal interest will not prevent me from fairly evaluating the facts of this case.
May I have a motion to direct Mr. Young to participate, please? Ms. McKenzie. Would you speak?
As Mr. Young explained, he has had business relations with the applicant, but as he stated, he is able to remain impartial in this case, and therefore I move to direct him to participate.
Any other discussion? Any objection? Seeing none, Mr. Young, you are directed to participate in case S11873-1, Powder Ridge subdivision. Are there any other disclosures? Mr. Young.
In the case of S11452-4 Shangri-La East subdivision, I have not worked for the petitioner or the representative, or I have walked up and down the property several times evaluating drainage ways for the neighboring developer. Thus, I have specialized knowledge of the property. My firm worked for the petitioner's representative on a separate project in the past. My firm has no ongoing work with the petitioner's representative. I have no financial or personal interest in the matters before the board. I can remain impartial in fact and action as a member of this board without personal bias, and my past involvement and personal interest will not prevent me from fairly evaluating the facts of this case.
I have a motion to direct Mr. Young to participate in case S11452-4 Shangri-La. Anyone at all? Mr. Story.
Excuse me. Yes, I move to direct Mr. Young to participate in case S11452-4.
And Mr. Cole seconds. Mr. Story, would you speak to your motion, please?
Based on Mr. Young's testimony, I don't see that there would be a conflict, therefore I'll be supporting the motion.
Is there any other discussion? Is there any objection? Seeing none, Mr. Young, you are directed to participate in case S11452-4 Shangri-La East subdivision. Mr. Young.
In case S11820-2 Upland subdivision, my firm has worked for the petitioner's representative in the past. We have no ongoing work with the petitioner's representative. I have no financial or personal interest in the matters before the board. I can remain impartial in fact and action as a member of this board without personal bias. My past involvement and personal interest will not prevent me from fairly evaluating the facts of this case.
May I have a motion to direct Mr. Young to participate in case S11820-2 Upland subdivision? Mr. Story.
And again, I move to direct Mr. Young to participate in case S11820-2.
Any other discussion? Mr. Cole seconds. Is there any objection? Seeing none, Mr. Young, you are directed to participate in case S11820-2 Upland subdivision. Are there any other disclosures? Okay. Seeing none, we will move forward. The next item on the agenda is the consent agenda, but we have no items. There's nothing under old business, which brings us to new business and public hearings for this evening. And during this evening's procedure, we will follow the procedure as outlined on the front of the agenda for the public hearing. After the staff presentation, the public hearing will be open, and the first person to testify will be the petitioner, including all of his or her representatives, and they get 10 minutes. And of that 10 minutes, they may reserve time for rebuttal. Representative of groups such as community councils or PTAs have 5 minutes, and individuals have 3 minutes. We keep time with this little unit up here, and the light is green while you testify. It turns yellow when you have 1 minute left, and when your time is up, it turns red, and there's a little buzzer. And if you haven't summed up, you should sum up quickly after that. When your testimony is complete, you may be asked questions by the board, so you should remain at the podium. And any individual may have appeal rights relating to any action that we take this evening, and those are outlined again on the front of the agenda. Okay, so with that, we'll have the first case. I did receive a request from the petitioner. And Mr. Young, you should leave. For a postponement if there was a short board, but there's not. There are 6 of us, and a short board is in case S10625-11 and case, we're taking them together, S11496-5, Eagle Crossing subdivision. The short board is defined as 5, and there are 6 of us. So we will move on with the case. And so in case S10625-11 and case S11496-5, Eagle Crossing subdivision, may we have the staff's presentation, please?
Madam Chair,
Ms. Chambers.
prior to staff presentation, I believe the petitioner believes in the letter that there may be a short board situation because of other circumstances, even though there are 6 that we find are able to hear the case tonight. It may benefit the board to hear that request first and then move on to the staff presentation if the board decides to go forward, because they do believe it's a short board situation for them.
Okay. Could we hear from the petitioner or the petitioner's representative?
Madam Chairman, my name is Connie Yoshimura, and I am the representative of Driftwood Bay LLC for tonight's hearing. With me is Suzanne Chereau, the attorney for Driftwood Bay LLC, and also Dave Grenier from Triad Engineering. And I will let Ms. Chereau speak to the potential of a short board.
Thank you. My name is Suzanne Chereau. I'm here representing Driftwood Bay. The petitioner is concerned that one of the members of the Platting Board, specifically Mr. Abel, may have, we're not sure, but may have potentially obtained proprietary information concerning the petitioner due to a relationship that one of his employees' spouses, in fact, worked for the petitioner, Mr. Yoshimura, for a number of years and had a lot of information about the company. And we don't know whether that's the case, but there is just a concern that that could be clarified and determined. Thank you.
Okay. Mr. Abel, would you care to comment on this?
Who are we talking about?
We're talking about Chris Camera.
Okay.
He is married to Cheryl Faulkner.
Never met Cheryl Faulkner. Never discussed. I've never even met her.
So I don't mean to question you, you're the planning board member, but I mean the concern is that there has been no information concerning the petitioner or the members of the petitioner that you obtained outside here.
Nothing that would make me decide one way or another on this case.
So then, Mr. Abel, for the record, Chris Hammerer is, I believe, an apprentice pipe fitter, and you are the business manager for the plumbers and pipe fitters. Is that correct?
No,
That's not.
pile drivers and dive.
Pile drivers, I'm sorry. That's what I meant. And Chris Hammerer is a person that you works in that capacity for your union.
He's an apprentice, yeah.
Yes, and he is married to Cheryl Faulkner, who was my accounting and manager for approximately 3 years.
Okay.
And I have been told on occasion that in the course of social activities that there was discussions. But if you tell me that there have not been, then I will certainly take you at your word.
Discussions relating to this particular case?
Yes.
Are you satisfied?
I take the Platting Board member at his word.
Okay. So, may we have staff's presentation, please?
Thank you, Madam Chair. These cases are requests to modify conditions of approval 1B for plating case S10625-9 and condition of approval 2A for plating case S11496-3 with time extensions for subdivision agreements 2006-021 and 2006-023. The petitioner is requesting modification of these conditions of approval as they relate to the time frame for construction of Eagle River Lane. Presently, the conditions require a full build-out of Eagle River Lane no later than October 1st, 2011. The petitioner has requested both conditions be revised to state, quote, constructing Eagle River Lane from Highland Ridge Drive to Ptarmigan Boulevard by no later than October 1st, 2013. The petitioner states the purpose of this request is to allow for adequate time to resolve the ongoing right-of-way issue with the adjacent property owner, Mr. Hanaway, to resolve the typical road section standard, and to resolve the requirement for pedestrian improvements. To give you a brief background of the case, the construction of Eagle River Lane has long been an issue, dating back to 2000 when the initial review of Eagle Crossing was done. At that time, the neighboring subdivisions objected to a connection between Eagle River Lane and Ptarmigan Boulevard. Conceding to the neighbors' wishes, the Platting Board deferred construction of this portion of Eagle River Lane until 2007. In 2002, the previous owner was approved to amend their phase plan and provide for the construction of Eagle River Lane to Ptarmigan Boulevard in 2003. Construction was not completed in 2003, and the property was sold to the current petitioner in 2004. 2 time extensions have been granted for the construction of this portion of Eagle River Lane. It was required to be constructed to full urban standards in 2008. That same year, conditions were amended to defer construction until 2009. In 2009, conditions were again amended to allow construction of Eagle River Lane to interim emergency access standards by October 1st, 2009, with full build-out to urban standards no later than October 1st, 2011. The interim emergency access was not constructed by the approved date. The petitioner had originally requested several amendments to the conditions of approval, but that request has been amended to address only the time frame for construction of the road. Full construction of the street has been deferred for many years. Anchorage Municipal Code 2175-010 requires subdivisions to provide efficient movement of vehicular and pedestrian traffic, as well as access for firefighting apparatus. This connection of Eagle River Lane to Ptarmigan Boulevard is required as it provides a secondary means of access to Eagle Crossing subdivision. The Anchorage Police Department, the Anchorage Fire Department, Municipal Traffic Department, Eagle River Street Maintenance, and Subursa Board of Supervisors do not support this request for time extension. Their concern revolves around public safety and the need for a suitable means of secondary access. Agency comments in the 2009 case stated that these accesses, and I quote, do not meet the required separation to properly serve as two distinct and separate fire and EMS access roads. Two separate fire and EMS access roads are required when there are more than 30 dwellings on a single access road. And in this case, there are at least 800 dwellings, end quote. That situation has not changed today. While the division does not support the petitioner's request to defer construction of Eagle River Lane any longer, it understands that time constraints prohibit construction of Eagle River Lane by October 1st of 2011. Thus, the division will support modifying the two requested conditions of approval to state, quote, constructing Eagle River Lane to the existing improvements as provided in the executed subdivision agreement signed by the developer from Highland Ridge Drive to Ptarmigan Boulevard by no later than October 1st, 2012. The developer shall assume the responsibility of reimbursing Subursa for maintaining Eagle River Lane from Highland Ridge Drive to Ptarmigan Boulevard from the date of this approval until the final road improvements have been completed and accepted by the municipality. This time extension will allow the petitioner sufficient time to secure all necessary permits and complete construction next summer. Additionally, the division will support time extensions of subdivision agreements 2006-021 and 2006-023 until October 1st of 2012. Thank you.
Are there any questions of staff? Seeing none, would the petitioner come forward and state your case?
Thank you, Madam Chair. Again, my name is Connie Yoshimura, and I'm representing Driftwood Bay, LLC. I am its CEO. With me this evening is Suzanne Chereau, the attorney for Driftwood Bay, LLC, and Dave Grenier from Triad Engineering, who is our civil engineer. I just want to confirm that the board members have received a supplemental packet of information that I prepared. Okay, thank you. And also, I would like to distribute a photograph of Eagle River Lane, secondary egress.
Thank you.
Before I begin my presentation, I would like the board to know that we first made this request in a somewhat different format in January of 2011. I would hope that the board would understand that we have worked diligently to try and resolve the legal issues and the topographical challenges on this matter, and that our delay that we have had over the past few months is not related to a calendar in which we simply don't have time to build this road. And that is very important to us for you to understand that. We are plagued by a legal issue regarding a variety of opinions regarding the trespass issue. We are unable to obtain a certificate to plat to complete a portion of Eagle River Lane on the Hanaway property, and I would ask Ms. Chereau to address that issue. After Ms. Chereau is done, Dave Grenier will address the physical and topographical challenges that the completion of Eagle River Lane faces. We appreciate staff's and the administration's support of a one-year extension. However, we do not believe that that is an adequate time frame to resolve the legal issues regarding Eagle River Lane.
Thank you. I already introduced myself. I'm Suzanne Chereau. I was asked by the petitioner to review the status of the Hanaway property and the title reports research and conflicting legal opinions that had been prepared and to comment on those. And for all the reasons stated in the memorandum that we submitted last week, my memorandum dated June 29th, which is included in there, it was our opinion, and we concurred with the opinion of Robert Regis, that a section line easement does not exist on the Hanaway property. And the reason for that is spelled out in detail in the memo, but just to summarize, section line easement law is very complex, and we're not asking anybody to actually for you to make that determination, but the factual history of the property actually is not complex and it's not disputed. Section 17, which is the section in which the Hanaway property is located, was unsurveyed and unidentified until 1949, and it was first homesteaded and taken out of the public domain in 1950, and the survey plat was not recorded until 1951. So it came out of the public domain when Mr. Hahn entered it, and then when the survey was done. And section line easements can only exist on surveyed and public land that is owned by or acquired by the state during the period of time that right-of-way legislation is in effect. This is supported by 1969 Attorney General's opinion and by the law of section line easements written by John Sedgwick, now the retired Judge Sedgwick. Between 1949 and 1953, it's hard to believe this, but between that period of time, the section line easement legislation had actually been repealed and was not in effect during the period of time that this property was surveyed. So there was not a time that the property, that the section line easement could have been established on the property before it went into private ownership and was surveyed. Again, there have been a number of conflicting legal opinions. There's title reports that say either it does not exist or they're not sure whether it exists. We're not asking you to make a legal determination, but what we are asking is that you will take note of the fact that if the developer were to try to go forward and construct the road and finish the road in the Hanaway property without either an agreement with Mr. Hanaway, and so far it is my understanding Hanaways have taken the position that there is not an easement on the property, or without a court determination, without one of those, that it will result in litigation and all kinds of financial costs and legal issues that would impact the developer. The developers worked hard to try to work out these issues. It needs the cooperation of both Mr. Hanaway and the municipality of Anchorage, and it's our opinion that these kinds of legal issues would very likely take longer than a 12-month, could potentially take longer than a 12-month period of time, even if everyone addresses it quickly and in good faith. So if you have any questions, I'd be glad to answer them. Thank you.
Can you hear me? The Reeves Amadio opinion was written on May 25th, 2010. That's the date that I have on the package that you gave me, or that I received. And then I'm looking at your memorandum, June 29th, 2011. Can you tell me what steps were taken between May 25th, 2010 to when you wrote your memorandum to resolve this legal issue? Thank you.
I'll let actually Ms. Josemer answer that.
The position of Dennis Weaver, the municipal attorney, for the past year and couple of months is that the section line easement does exist. And that's been their position as of last week when we met with Mr. Wheeler, Jerry Weaver, and George Vacalis, the city manager. Between that period of time, we have had several meetings with Mr. Wheeler. We have had several attorneys involved in this situation. If I can speak frankly, the reason Ms. Chereau is here is simply because the municipal attorney's office told Robert Regis that he could no longer participate in this case if Res Modio expected to receive any other business from the municipality.
So I guess my question is, what steps can you just, other than just saying there's been some meetings, have there been any steps taken to resolve this legal issue since May 25th, 2010? Has a lawsuit been filed?
No, sir. A lawsuit has not been filed. We have made every effort. I do know that the municipal attorney tried to order an updated title report, which is the second title report that you received in your packet. I do know there have been at least one meeting between the municipality and Mr. Hanaway, to which we were not invited to try and resolve this issue. We have met with Mr. Hanaway, but it's really hard to negotiate and resolve a matter when the municipality refuses to acknowledge the fact that there might not be a section line easement there. Your packet does have, as a piece of information in it, if I can go to the packet, email from Debbie Osiander to Rick Davidge, who is one of CY, is a project manager for CY Investment, which states, I talked to Kiefer, who confirmed the trespass. He indicated the city would be negotiating for possible exchange of easements over this winter. I'm setting up a meeting with the mayor to brief him on the issue. The city appears to believe the engineer who designed the project has liability and that it could be resolved through their E&O policy. Documents presented to the city showed a legal right-of-way, so at this time I'm not sure who can apologize for what. Mr. Hanaway had asked for an apology from the city. Since that time, I don't believe the city's position Mr. Wheeler's position has changed.
Okay, then I just have one more quick question. I apologize. Ms. Scherow, you indicated that this is not going to be enough time and that there's going to take more time to resolve this legal issue. What needs to happen to resolve this legal issue that's going to take the time? And maybe you can you explain that to me?
Well, I think there are one of two options. If, in fact, I think city could acknowledge, that there is this valid dispute and that the owner does not believe there is an easement and all. I think the first step, because people always want to avoid litigation, the first step would be to try to have all of the parties involved sit down and see if an agreement could be reached that would be acceptable to Mr. Hanaway and that could be then put in writing that would clear this so that the developer would not be faced with potential litigation. And I think some period of time is required to do that for the parties in good faith to do that, particularly if the Platting Board, as part of whatever decision, requested the city to participate in that and go forward in that step. If that does not work, the only way to do it is to have a a judgment action filed with full briefing and arguments and a court decision, and you as an attorney know what the time period can be on that. Those are the only two ways that I know that would resolve that would take away the potential problems for the developer.
So then my last question again, and this is to Ms. Yoshimura, I apologize. Since those are the two courses of action for resolving this, can you explain why neither of them has been taken up to this point, and when is a realistic date for moving forward to resolve the issue?
Well, I do not have with me here, but I can assure you that I have numerous emails going back over this past year regarding this matter. Between Mr. Regis and Suzanne Scherow, we also engaged Mr. Coffey, who I'm sure you're all familiar with, to also assist us in working with the administration to try and resolve this situation. He has had numerous meetings and conversations with Dennis Wheeler. Actually, Mr. Wheeler is the one who provided us with the updated title report through Mr. Coffey. So I can assure you that we have utilized and expended all of the resources possible to us without going to court.
When is a realistic timeline for when there's going to be a step toward resolving the issue?
I would think if the Platting Board would make in one of their findings that to direct the municipality to engage in a three-way negotiation between Mr. Hanaway and ourselves, and I would think a realistic time frame would be approximately 6 months to reach some sort of an agreement. Unfortunately, what has to occur is that that agreement has to be reached before Mr. Grenier, who is our civil engineer, can appropriately work with the road design. And I would ask Mr. Grenier to come up to further address the time frame, because after that agreement with Mr. Hanaway can be reached, then we have to design the road.
Thank you very much. Thank you.
Ms. Yoshimura, just to let you know, you have 3 minutes and 50 seconds left in your time allotment.
I will.
And if you wanted to hold some for rebuttal.
Yes, we do. 2 minutes. Thank you.
Okay.
Thank you.
Yes, Madam Chairman, members of the board, my name is David Grenier with Triad Engineering. We've been working on the Eagle River Lane issue for a number of years. We did the design of the emergency access road, which is in place at this time. And as far as time frame, once the right-of-way issue is taken care of, a project of this type, once you start the design, go through the review process, and get your final permits and notice to proceed, you're looking right at 1 year. So from the standpoint of the time frame, the one-year extension, if we receive that in the next couple months, if we received a 1-year time extension, we would need to have notice to proceed to go on this road within the next 2 to 3 months. And the reason for that would be we need the right-of-way resolved. Other physical challenges are wetlands. As far as the urban section versus a rural section, the number of or the type of sidewalks and walkways on each side of the road. Within our right-of-way, we have a steep bank, which is shown on the photos, and also the coordination with the extension of Eagle River Lane up to Eagle River Road. There are 2 projects that need to be coordinated. With that, I'd like to reserve the rest of the time and answer any questions.
Any questions for Mr. Grenier? Mr. Story?
Yes, Mr. Grenier, it sounds like you haven't done any of the design yet. And what were the alternatives if the right-of-way wasn't available? Or, I mean, if you haven't done any design, you're counting on the right-of-way to be available for your design, correct?
Madam Chairman, Ms. Story, we've done a number of concept studies. We've also done the topographic survey. As part of the emergency access road, we did a complete design with the intent to expand the road. So we have worked on that. The alternative in the lack of an easement is to build a road within 30 feet. The subdivision agreement as it's written now would be 30 feet plus, so it physically would not fit within those constraints. So that's our situation. We've got a 30-foot right-of-way without the other half of the right-of-way. The improvements as written in the subdivision agreement cannot be constructed.
It just seems to me like you've been working on this for an awful long time, and always in the impression that you're going to use the right-of-way, so it just seems like the design should have been done by this point to facilitate the construction of the road.
As far as a developer going into if I understand your question right, we'd have to have a revision to the subdivision agreement to build within that 30-foot right-of-way. We have the concept for that.
Well, I mean, you've been all along thinking that the right-of-way would be available for the design, correct?
That would be the prudent way to do it, because this is a collector road, and it should not narrow down from a 60-foot right-of-way down to 30 feet. And also the alignment at Ptarmigan and Eagle River Lane would be offset. So you've got from Eagle River Road down to Ptarmigan, you'd have one road. You'd have to shift the center line over. So it's complex, and the prudent way to do this is to build the road within a full right-of-way.
Yes, and I guess it's not so much of a question as a statement. It just seems like it's been going on for such a long time. It seems like the design would be at a point that they would be able to construct it. I mean, there's been subdivision agreements for construction of that road for some time now, which for the construction it needs the design, and now you're saying to us that the design isn't done and it's going to take up to a year from this point, or possibly more, to have the design and the construction done. It just seems with the other subdivision agreements that were in place that would be done by now.
That's a fair statement, but keep in mind that this is a different developer than the one that entered into the original agreements. So we've got a new developer that's taking over these responsibilities, and
yes, it's still been several years.
Correct. If I'd make one other point on that, the amount of traffic that is using the road at this point is very minimal. There was a traffic study that was done on the road that showed 300 cars total traffic count for that day, and the full build out of the road per the municipal study is approximately 1,900 cars, and we're not anywhere near that point. The health and safety issues have been addressed by having the second access. We felt that was very important to do, to have the access road constructed, and so we feel we've addressed that issue.
Are there any other questions for any of the petitioners, Ms. Yoshimura, Mr. Grenier, Mrs. Shiro?
I do have a question for Ms. Shiro and Ms. Yoshimura.
Thank you.
And maybe I'm confused a little bit, but the MOA says that the right-of-way exists, correct? And they've given you the authority to build within the right-of-way, which the municipality has the authority on?
The municipality, in my opinion, does not have the authority to allow us to build on Mr. Hanaway's property. I cannot, in order for me to obtain permits and financing, I have to provide a certificate to plat for that portion of the road. And as you can see by the two title reports, that's not possible. I cannot get a certificate to plat.
But still, I mean, you talked about the litigation also, and wouldn't the litigation would be between the MOA and the property owner?
Well, I think it would depend on who, if someone tried to go on the property and build the road, Mr. Hanaway would have a right to bring an action. Otherwise, there would have to be a declaratory judgment action, and as determining all the parties to that probably would involve the developer and the municipality.
And again, in the statement that I made to Mr. Grenier, it's been several years now that this has been in the process of both design and the subdivision plat, and it just seems like it's, way down the road here that we're talking about right-of-ways and ownership. It just seems like something could have been done at an earlier time to facilitate the neighborhood and the people that are impacted by the slow process.
Well, I think as you can see from the, I don't know if you've seen all the correspondence and the opinions, but it's been, I think initially the original developer relied on information that it was there, but then the research, people did more research and more specific research about the history of the property and exactly what had happened, and then identified that it was an issue. It's been ongoing, and when it became really clear, I think the developer has tried to address it.
The prior developer put in a water line on the Hanaway property. I was not the developer at that time, but I have been told that municipal officials and police went to the property and stated that there was a section line easement and they were coming through with the water line. I'm not that type of developer, and I'm not going to trespass on someone else's property. I will not develop this piece of property without a certificate to plat. I don't believe that I can obtain one from any title company in the state of Alaska at this time. This is not a delay tactic on our part. We believe there is a legal issue that exists, and we also believe that once that issue is resolved, that there are other challenges with the property topographically. We would like to see the official streets and highways position give some reconsideration, which I understand they are doing regarding the status of this road. At full build-out, USKH and the municipality basically concur that there is only going to be 1,900 cars that use this road as a secondary egress, and in reality there are only 300 cars a day currently using this road, and we built it to an emergency egress standard which is adequate for the minimal amount of traffic that currently exists. So I would echo Mr. Grenier's comments that we have addressed the health and safety issues. There is adequate fire access, apparatus access. Mr. Vacalis opened the road, even though this board said that the road was to be closed. And so now there is free secondary egress for both health and safety and personal vehicles.
Thank you.
Any other questions for any of the petitioner's representatives?
Okay.
Seeing none, thank you. Is there anyone else wishing to testify in cases S1062511 or and S11496-5?
Hi, my name is Linda Kovac. I'm with Subursa. That's Chugiak, Birchwood, Eagle River Rural Road Service Area Board of Supervisors. And we look after the taxpayers' money as regarding local roads. Hopefully you got our letter. It was dated April 26th. This is a supplemental, 16 pages. Okay. We do not support any more delays. We don't see any progress as being made in the years that have transpired. We're tired of waiting. If there's legal problems, we say solve them. It's not fair to the hundreds of homeowners that are at risk with a substandard road that they've got right now. They've been waiting a long time. As far as having teeth, the municipality has to have some kind of bond, some security. If the petitioner goes into default, there has to be liens. In other words, don't assume that the taxpayers are going to build this road to full municipal standards. Also, regarding maintenance, the emergency access road was built to a draft standard, and the draft standard says interim emergency and access roads constructed to this standard will not be maintained by the municipality. The municipality will only assume maintenance responsibility if the roadway is constructed to full public roadway standards. Currently, Subursa is maintaining this road. We don't think that's fair to the taxpayers to do that. Even the standard says it's not fair. So whether you approve this extension or not, we do like the departmental recommendation that states the developer shall assume the responsibility of reimbursing Subursa for maintaining Eagle River Lane from Highland Ridge Drive to Ptarmigan Boulevard from the date of this approval until the final road improvements have been completed and accepted by the municipality. That's all. Questions?
Any questions for Ms. Kovac?
So, for clarification, who's paying for maintenance on the road right now?
Taxpayers.
And is that by agreement or by interpretation or why?
I don't know exactly how it rolled out, but there was, after the emergency road was completed, there was a inspection by the municipality, and they accepted the temporary road. So there's a 2-year thing on the road. So for 2 years, I guess we're on for maintaining it. But after that, it's really shouldn't be the taxpayers that pay for it. Okay, thank you.
Through the chair, I'm sorry, I had a question for the last, I was slow on the take here. Thank you. So, can you clarify for me, in your opinion and being in your position there, if the municipality agreed to it, and correct me if I'm wrong, but through reading through the literature, the municipality is the one that ultimately made the decision to unblock this. At some point, this road was blocked through traffic and was supposed to be just for emergency vehicles. So why is it your opinion that the taxpayers shouldn't be participating in the maintenance of this road at this point if the municipality inspected and accepted it up to a certain point?
Well, because this is something new that the municipality has tried. This was even a draft standard to even put this emergency access road in, and even the draft standard says we shouldn't be maintaining it. The taxpayers shouldn't be maintaining it. It's a temporary road, and it was meant to be put to full municipal standards. That was always the intent when they allowed you, and in fact, I'm not sure they even told you it was a draft standard last time they presented it to you. But it was a draft standard. It's never been accepted by the municipality, the standard. So when the municipality got their legal opinion to open it to the public, and my understanding of that was that it's supposed to be open for emergency access, but you couldn't tell if a normal car was having an emergency, even if they were speeding. So to stop it, a policeman stopping a speeding car on that road would be counter to the function it's supposed to provide, which was to provide emergency access. So then they just opened it to the public. That doesn't stop the fact that this whole premise of this road was a temporary road, and it was not supposed to be maintained by the municipality, with an incentive for the developer to fix it to municipal standards as quickly as possible. Actually, the draft standard really was not intended for a whole, huge subdivision with 800 homes. It was supposed to be for, individual pieces of property or small little subdivisions. Nothing on this nature.
Thank you.
Mr. Kiefer.
Yes, through the chair and to the board, just to offer a little bit of clarification on maintenance. Last fall, when we did what we call a pre-final inspection on the interim improvements, there was a discussion on maintenance responsibilities, and maintenance responsibilities are split between the Subursa Road Board and also the developer at this point. Any routine snow plowing, any routine sanding during the winter months, and any grading in the summer that might be required is absorbed by the Subursa Road Board. However, any drainage issues that result as a result of frozen culverts or other drainage problems that might develop in turn, those are handled by the developer. And last winter, they did follow through and they did handle 2 freezing problems we experienced as we approached breakup.
Are there any other questions of staff?
Through the chair. So why has the staff then recommended that the developer have to pay, I think the language at page 4, why the change if the public is using it and we have an arrangement in place as it stands right now?
To the board, Mr. Cole, it's because of the time extension that has been requested. This was not intended to be an ongoing maintenance agreement, even if it was verbal. This was intended to come to a close with the final improvements this fall being in place.
But let's say that they did do the improvement and pave the road to the standard. Who would pay for the maintenance then?
Sir, at that point, all maintenance responsibilities would go to the Subursa Road Board, because at that point, it would be built to full standards.
So the theory is that because it's not built to full standards, the developer should pay for this delay.
Sir, that's correct.
Thank you, Madam Chair.
Is there anyone else wishing to testify in these 2 cases, case S10625-11 and case S11496-5?
Good afternoon, Madam Chair. My name is Laura Hutto-Demander, and I am here in 2 capacities. I am the Platting Board representative for the Eagle River Valley Community Council, and I believe you've received the written comments from our President, Therese Voll, in your packets today. The Community Council voted very narrowly to support the developer's initial request for an extension of time and a change in the standard required for Eagle River Lane from Ptarmigan to Highland Ridge Road. They asked me to come today to inform you that there was a very emotional vote. Mr. Hanaway is really emotionally involved in this issue, which I think contributes to the difficulty they've had in resolving the issue. There were essentially 2 camps. Mr. Hanaway's camp, the people who understood his issue and agreed with him, and the people who basically have said, you've had enough time, you should have finished the road, you've had plenty of extensions. And so the vote was 8-7. I am also the president of the Driftwood Bay Homeowners Association. I represent 100 homes at the end of Driftwood Bay, and I personally use this road at least once a day. On behalf of the Homeowners Association, I'm here to support the developer's request for an extension with the understanding that they are going to maintain the road, and that is including plowing, sanding, all those things that are required of a road, as well as fixing the potholes and keeping the dust down. Living there, that is one of our primary concerns, is the dust that's generated when cars drive up and down this road when there's been no rain. So I'd be happy to answer any questions.
I'm sorry, I didn't catch your name. Could you?
Laura Demander.
And could you spell your last name, please?
Demander.
Thank you. Are there any questions for Ms. Demander?
I have a question too.
Mr. Cole?
So, is the maintenance get done better if the developer does it than rather than the municipality?
The road gets plowed at this time, but it is literally pothole after pothole after pothole, no matter which side you drive on, because it's a combination now of the recycled asphalt surface they put down and the gravel that was put down when it was icy. I don't think the taxpayer should have to pay for it. That's essentially what we've come to agree to with the developer. We've had many meetings, the board for the Homeowners Association, and Ms. Yoshimura and Mr. Davidge.
Any other questions for Ms. Demander? Thank you.
Thank you.
Anyone else wishing to testify in these two cases, case S11496-5 and case S10625-11?
Madam Chair and the board, my name is Bill Holland. I'm come in three different capacities. One is a resident of the Eagle River Valley Community Council and living in the council area and a user of the road as well. Also as a board member on the Eagle River Valley Community Council and board member on the Subursa board. First thing I want to identify to the board is that the petitioner has exercised due diligence with the community council over a number of years by attending the community councils and keeping the council informed on their progress in a number of different areas. However, as a resident and user of the road, my recommendation to the board, and this will be my final comment, is that the petitioner not be allowed an additional extension to this point based off of two reasons. One, the municipal attorney has addressed to our community council directly that there is the right-of-way does exist, and two, that due diligence has proceeded thus far. And so I don't have any other comments unless there's any questions for me.
Any questions for Mr. Holland? Ms. Moses.
Madam Chair, sir, did you say that you were at a meeting where the municipal attorney stated there is not?
No, if those were my comments, then I stand corrected. The municipal attorney at the community council meeting, along with 15 other department heads, attended our community council meeting to include the city manager, identified that there was, and explained to the public at that time that the right-of-way does exist.
Any other questions for Mr. Holland? Thank you. Anyone else wishing to testify in case S11496-5 and S10625-11? Anyone at all? Do you want to use your 2 minutes and 18 seconds of rebuttal?
Madam Chairman, a few points. One on the road, the emergency access road. The whole purpose of that was an interim improvement so that the health and safety issues could be addressed. It was signed for emergency access only. It was never meant for the amount of traffic that's on it now. From the standpoint of maintenance, because of in our opinion, the legal issue that's facing this project, we feel that if we can get that resolved, we will move forward. And as far as the maintenance, Connie, you want to address that?
On behalf of Driftwood Bay LLC, I will make a commitment to maintain the road from this date forward, with the ability to have a one-year extension. I have listened very carefully to the comments made this evening and the questions asked, and I would ask that the board favorably support the staff recommendations for a one-year extension under the following circumstances: that the board make a condition to resolve the issue regarding the right-of-way on the Hanaway property in a three-way dialogue between the municipality and the Hanaways and Mr. Hanaway and the developer. I have been unable to successfully engage the municipality to assist us in resolving this issue. But if the Platting Board would so direct, I believe that would go a long way in assisting in resolving this issue. Thank you. Be happy to answer any further questions.
Mr. Cole.
The picture that you sent me, is this the emergency road?
Yes, it is, sir.
And is it 60 feet? How wide is this?
The travel surface that you see is 26 feet from shoulder to shoulder.
So this doesn't interfere with the right-of-way issue that we're...
In this particular area, no. This is within the full right-of-way section. There's also swales on both sides.
Section 18? Isn't Mr. Hanaway's section 17?
That's correct.
And is the road within section 18?
It's within 17 as well, but it's to the south of Mr. Hanaway's property.
So it doesn't, it avoids the right-of-way issue. The permanent one would not.
That is correct. The permanent one would widen this one out that you see here now.
And that would do the encroachment into Mr. Hanaway's, which is the issue that you can't get resolved.
That is correct. One other point I'd like to point out as far as the photo goes, if we go to full urban standards, the area that is to the right is classified as A wetlands, and so we need to resolve that with the Corps of Engineers to go to the full urban requirements with the 8-foot trail beyond, a separated detached trail beyond the curb and gutter. So
what steps have been taken to resolve that issue since last year?
The main focus of last year was to get this emergency road in. We worked through the approval process and the successful construction and acceptance of the road.
So that would have been in December of 2010?
Actually, the inspection was in October of 2010
and then it was
with the paperwork.
A little bit later. Okay. And then since that time, have you addressed this issue of the wetlands?
Mr. Cole, I would just like to point out as a private developer that when you're faced with a major legal obstacle like we believe we are, until that issue is resolved, it's very difficult to expend money dealing with the Corps and other entities as well. We consider this a major roadblock, and I believe that the paper, the legal opinion by Robert Regis and other information that we provided and an earlier title report shows that we have been working on this issue for a long time. And we're here actually to almost plead with you to put a condition on here that requires the municipality to engage with us in an acknowledgement that there is indeed an issue here that needs to be resolved. We can't resolve it by ourselves. We don't believe in that litigation solves any problems. It's very expensive, and then it's usually resolved on the courthouse steps. And so it's a longer, more drawn-out process. I can assure you that we've worked diligently with Robert Regis, Dan Coffey, Suzanne Chereau, and a variety of people to try and resolve this issue. And we're here to ask, basically, for your help, because we're not getting very far, as you can see. Thank you.
Any other questions for the petitioners? Mr. Story?
What are the main issues of resolving the right-of-way?
Well, I would say the first would be an acknowledgement that there is a problem. We believe there's a problem. The title companies believe that there is a problem, and the municipal attorney's position is there is no problem. Now, I can understand why they feel that way, quite frankly, because then they would have to acknowledge a certain amount of liability with the fact that there is already a water line that is on the Hanaway property. So I can understand why they want to stonewall this issue, so to speak, but in the meantime, it doesn't help us resolve the issue that we're faced with. As you can see, from a prior email, that it goes back to who's going to take responsibility for the trespass once there is an acknowledgement that it exists. And is that the engineer, PTS, or is that the municipality for allowing the water line to be installed in the first place? So, or is it, an insurance issue for not only PTS, but perhaps John Tyndall, who wrote the legal opinion that said that there was a section line easement there. So it's a very complicated issue. So I can understand why they're stonewalling, but it doesn't help our problem.
Ms. Moses? You're done. Any other questions for the petitioners? Thank you. So we'll close the public hearing, and the matter rests with the board now. Are there any questions of staff? Mr. Story?
Through the chair, staff, is it in your opinion that the developer is allowed to construct within the right-of-way that the municipality feels is theirs?
Through the chair, Mr. Story, we go back all the way to a legal opinion that was struck that Mrs. Yoshimura actually referred to, that was authored recently by Mr. Attorney Tyndall, and then agreed to by the municipal attorney in the late 90s. So from that perspective, that's what allowed the water line to go into that area in the first place. I was in a position at AWW to administer those types of an agreement for water and sewer extension. I made that legal opinion come about because I did not want trespass. So we're still relying on that legal opinion, and then that was reinforced last year once again by the municipal attorney's office. It's just recently the debate has come into play as to whether or not it's really there. So because of questions back in the late 90s, we have a legal opinion, and then it reinforced once again last year.
So is the municipality, would they be interested in having an agreement with the developer, a hold harmless agreement for construction within the right-of-way?
That would be a question for the legal department, and unfortunately, I'm not part of that. Or fortunately, however you look at it.
Thank you.
Ms. McKenzie?
Through the chair, question regarding the appropriateness or the authority of the Platting Board to condition the modification of the condition of approval to require settlement discussions between Mr. Hanaway, the developer, and MOA?
Through the chair.
Go ahead. Go ahead.
Through the chair, I don't believe that that staff has the authority to agree to anything, and I'm not sure how that particular condition would be enforced and require the municipality to enter into any kind of negotiations with the developer and Mr. Hanaway.
Through the chair, this is related to a private requirement put on a entitlement requested for a development, a private development, is to oppose to a separate public project going through. So it's the requirements for this platting action are upon the developer. The municipality will assist where possible on these situations, but we do have a determination, as Mr. Kiefer had said, regarding the right-of-way.
Any other questions of staff? Ms. Moses?
Madam, is it based on something staff said? I have a question for the petitioner regarding Mr. Story's question on hold harmless or full ownership of ultimate responsibility. And I guess I'm curious to know if the petitioner, if that would change anything. Just to any of the petitioner or petitioner's representatives, my question is based on staff's, or Mr. Story's question and staff's response regarding hold harmless, or the fact that the municipality says it's there, will they ultimately take full and all responsibility for that? Would that change your position here or take care of it?
Okay, I have two comments. One, included in the memo, when they say that the municipalities always said that there was, in fact, a right-of-way. There's a 2001 memo, in fact, which says there isn't, and there's the emails that, even within the municipality, there have been conflicting opinions in 1997 and 2001 and 2009. So I would just like to clear that. The concept of a hold harmless indemnification agreement, which municipalities usually, my experience has been, don't like to give, but I mean the concept that, you would have no costs or liability if you proceed with the road on this property is something that could certainly be explored. I think to commit to it without knowing what the, terms of it were would be premature. I mean, we'd have to know what those terms were. Certainly, if it was broad enough and complete enough that would satisfy, that you could go through and you wouldn't have to be worried about litigation or any costs, that's probably very appealing to the petitioner and would certainly solve some issues. But again, it would, how that comes, Brent would know. And Amy, coming down to what the actual terms of the agreement were, we'd need a little time to work that out. But it certainly is if they have said consistently there is a right-of-way. We have, 4 people in a title company saying there isn't. That gives a developer a lot of pause. And again, I think the 2 attorneys, I would just like to say, the attorneys who were asked to look at this on behalf of the developer, both Mr. Regis and myself, were not asked to come forward and say there was not an easement. I mean, the thing that we were asked to do was look at it and come up with an opinion. So those are my comments related to that.
Any other questions of staff at this point? If not, then I'd entertain a positive motion on the request to modify the conditions of approval. Ms. McKenzie.
In the matter of case S-11496-5 and S-11625-11, I move to modify condition of approval 1B for platting case S-10625-9 and condition of approval 2A for platting case S-11496-3 to state constructing Eagle River Lane to the existing improvements as provided for in the executed subdivision agreement signed by the developer from Highland Ridge Drive to Ptarmigan Boulevard by no later than October 1st, 2012. The developer shall assume the responsibility of reimbursing Subursa for maintaining Eagle River Lane from Highland Ridge Drive to Ptarmigan Boulevard from the date of this approval until the final road improvements have been completed and accepted by the municipality.
Mr. Story seconds. Would you speak to your motion, please, Ms. McKenzie?
Certainly. Based on my review of the materials, it appears reasonable to me that this right-of-way does present a very complicated legal issue. There have been a number of attorneys that have looked at the issue, and a couple of different title companies have also weighed in with differing opinions. I've also reviewed the USKH traffic count analysis that predicts vehicle usage of around 300 vehicles a day. I understand that there has been an emergency access road constructed, and based on testimony tonight, it appears that this road construction has addressed safety issues, at least for the next couple of months till some of these issues can be resolved. The fact that the developer will be required to maintain the road until full build-out provides some incentive for discussions to move forward expeditiously. I understand that the community that's served by the road is in support of this, as well as the Eagle River Platting Board. It appears that there's never any guarantee that the developer will be able to reach an agreement with Mr. Hanway. It appears that he may be emotionally involved in this issue, but at least giving them a little bit more time provides an opportunity to have those discussions.
Is there any other discussion? Mr. Cole.
Ms. McKenzie, I agree with much of what you've said today. I have some significant issues with the way this is proceeded and what appears to me to be the delay. I've read a lot of comments from individuals who commented upon this, and I particularly think the council that has indicated that they've asked us not to approve this. Those people are the people that are living out there and are dealing with these issues on a daily basis. And I'm particularly sensitive to them, and I highly value their comments. I applaud the petitioner for becoming involved with the situation, but when I look at the history of this, it does not seem to be moving forward to me, and I can certainly appreciate legal disputes, but from what I hear and what I have heard and read, it sounds like somebody just needs to move forward and litigate this thing. Because if people are emotional and they won't negotiate, sometimes you have to take the step forward and move the process along. And I apologize for some of my questions, but I was trying to get at, what has happened since the first memo was written. And I just didn't come away with a good feeling that we're moving forward. I also want to say that I have a hard time with the petitioner having to subsidize, even at her voluntariness, the road that the public is using. It sounds like people are using this road. If that's the case, to me, the municipality should be paying to maintain it. I understand kind of the philosophy that, hey, we have her pay, but if the people are using the road, the municipality should pay. I philosophically have a difficult time with that concept. I totally respect your opinion and the motion, but I intend to vote against that.
Would you care to offer an amendment to the motion to take out that portion?
I think at this point I will let the other board members decide what they feel is the best thing. My vote is that the extension shouldn't be approved. This thing should just move forward, and somebody should start taking steps to bring this to a conclusion, because too many people have been depending upon it for too long. And so I would vote no, both to the continuance and to the developer being saddled with the costs.
Is there any other discussion? Mr. Story?
Well, I plan on supporting the motion, and I do understand the frustrations and value the residents' concerns. I do think there's been a lot of unnecessary delays in the project. I do believe that it can be finished by 2012. I think that it, because that road wasn't built out to municipal standards, that the developer, because they have stalled for this long and have a non-standard road, should participate in the maintenance of that road. I think some of the right-of-way issues could have been taken care of earlier than it has been in the last several years now. I think the developer could work with the municipality and come up with some type of agreement, either to, some type of a indemnification or hold harmless agreement with the municipality. If they are so steadfast that that is their right-of-way, it seems like they would provide the developer with an agreement. So I plan on supporting the motion.
Ms. Moses?
Madam Chair, I do not intend to support this as written. First off, along with some of the other board members and members of the public, one is that the homeowners association, the community council, those who live in the community support an extension and are here in support of the petitioner. I think that the road service representative made a valid point, but it's almost resolved itself temporarily in consideration of this extension, as the petitioner has offered to take over that maintenance, and that's made part of the verbiage here. So I can appreciate the concern of the road service folks and the protection of the taxpayer, although ultimately the taxpayers would be bearing the burden sooner anyway for a road that's already being used as a public fairway. I have watched this case from way, 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 way back. I am of the opinion that with just a one-year extension, we'll be here in 1 year addressing this. Working in real estate in different capacities in this industry, hearing some of the testimony, verbiage such as highly emotional, all these different legal opinions, I am very resistant to believe this will resolve itself by this time next year, essentially. In addition, I somewhat disagree with one of the comments that it's time to move into litigation. In my 15, 20 years plus in real estate, generally speaking, that's when you lose the support of homeowners, community members, of which right now they seem to be wanting to work forward with all involved. And I'm also concerned with the verbiage here as this motion that, to me, I feel like the municipality has said, yep, the easement's there, but if it's not, that'll be on the developer's back. That has to be resolved. I can certainly see from a private sector developer's perspective where that is, quite frankly, scary. So to me, there's just too many things standing out. I don't think that it's a ploy, if you will. I'm familiar with this developer, the projects here in Anchorage, Eagle River. That's not been the MO, if you will, and so I'm hesitant to think so. And all the efforts that have been made on their behalf to work forward. So I will not be supporting the motion as it is written.
Would you care to offer an amendment?
How do I do that?
Something that you could support?
I would amend I offer to amend the motion to read a time extension until October 1, 2012. And I guess I'd have to think through it for a moment, but including some verbiage such as the petitioner requested, and I know that staff wasn't sure we had the authority to mandate it, but something in there where this does need to move forward with the three party. The municipality needs to participate in order to move this forward. So if someone has a thought on the verbiage.
So are you making that a formal amendment? It seems like you kept the first part of it. In fact, what part is it of it that you don't like? Okay. In the meantime, Ms. McKenzie.
Through the chair, did you want to brief at ease to work out the language?
Yeah, that's what we're talking about.
If you could call for a 5-minute at ease.
Okay, we're going to take a 5-minute break, and okay, we're back. And we left off with Ms. Moses going to make an amendment to the motion. Thank
you. Madam Chair, so can I just state my amendment at this point? Mm-hmm. Thank you for the time to get my thoughts together there. So my amendment to the motion is to change B from October 1, 2012 to October 1, 2013, and add the following language to condition A. Give me just a minute.
You're also changing the date in A to 2013 as well?
I thought I had, yes. Adding this verbiage to A as well, and it can just go, I think, just at the end, after municipality. The municipality shall work with the petitioner and property owner and private property owner on resolving the section line easement issue. Period.
Is there a second? Mr. Story seconds. Ms. Moses, could you speak to your motion?
Thank you, Madam Chair. It's my intent with these changes is, just as we discussed, to have all the parties involved move forward. And although this language may not be enforceable, if you will, I'm hoping it'll the intent is to put pressure on the municipality and the city attorney's office to resolve this issue. As another board member said, it's time to move forward. So I'm hoping this language, the intent and my hope of this language is that it's strong enough to encourage that.
Is there any other discussion on the amendment to the motion? Is there any objection to the amendment?
Does that mean it, Madam Chair, point of clarification? When you say objection, what do you?
Well, if we don't object, then it will move forward with that language to the main motion and vote.
Oh, okay. No, I don't object. That's going to be what it is, but we're still going to vote. Right, okay. No.
Okay, so that passes without objection. And now the main motion reads, approval of a request to modify condition of approval 1B for platting case S10625-9 and condition of approval 2A for platting case S11496-3 to state, constructing Eagle River Lane to the existing improvement as provided for in the executed subdivision agreement signed by the developer from Highland Ridge Drive to Ptarmigan Boulevard by no later than October 1st, 2013, and the developer shall assume the responsibility of reimbursing Subursa for maintaining Eagle River Lane from Highland Ridge Drive to Ptarmigan Boulevard from the date of this approval until final road improvements have been completed and accepted by the municipality. And the municipality shall work with the petitioner and the property owner on resolving the section line easement issue. And B, approval of the time extensions for subdivision agreements 2006-21 and 2006-23 until October 1st, 2013. Is there any discussion? And I have a feeling that there is objection to the motion, so we will vote. A yes vote supports the approval of the time extensions and the changes of the condition of approval, and the no vote not. So there are 5 positive votes, so that approval is granted. So we'll have a second here while we retrieve Mr. Young and move on to the next case. Yeah. I figured that was right. Okay, Mr. Young is back with us, and we'll move on to case S11873-1, Powder Ridge subdivision. May we have the staff's presentation, please?
Thank you, Madam Chair. This case is a request to remove conditions of approval from previous platting actions requiring further construction of Powder Ridge Drive from the Coley Way southward to Stephen Valley Drive. The planning behind Powder Ridge dates back to 1994. At that time, Eklutna was in talks with the military about a possible land exchange that would provide additional land for development to the southwest of Powder Ridge subdivision. This would provide a connection to Artillery Road to the south, but according to Eklutna, the events of 9/11 changed everything. Eklutna states that since then the military has been unwilling to negotiate a possible land exchange, making a possible connection to Artillery Road unlikely. About 5 years ago, Eklutna explored another possible land exchange with the Alaska Railroad to acquire Track C, which adjoins Powder Ridge to the west. After due diligence, Eklutna opted not to acquire Track C. Eklutna developed the first phase of Powder Ridge subdivision in 1999. At that time, Powder Ridge Drive was constructed to the edge of Nicoli Way. During subsequent phases, however, the remaining approximately 960 feet of Powder Ridge Drive extending south to Stephen Valley Drive was never constructed. In 2004, during the development of phases 5 and 6, Powder Ridge Drive was required to be constructed. That requirement was deferred to a later date. Eklutna recognizes that the extension of Powder Ridge Drive is necessary for future development, but not with this proposed development, Phase 7. With Phase 7, they plan to extend Vasily Drive south to connect with Rosser and provide connectivity throughout the subdivision. Municipal Traffic Engineering had some comments on this case. They do not object to this request as they recognize the construction of the remaining 960 feet of Powder Ridge Drive does not accomplish much. However, they do have a couple of concerns with regard to traffic safety, and those comments are actually outlined in your staff packet. Although some agencies have expressed concern, the construction of the roughly 960-foot remaining portion of Powder Ridge Drive accomplishes very little to lessen the traffic on the residential streets in the neighborhood. As was stated previously, Eklutna plans to construct Vasily Drive southward connecting to Rosser Drive. If Powder Ridge Drive were constructed south to Stephen Valley Drive, it is likely to get very little use. The bulk of the traffic will continue to use the local roads, taking the path of least resistance to access Eklutna Park Drive. With future development south of Powder Ridge Drive uncertain, staff finds that the requirement to construct the remaining 960 feet of Powder Ridge Drive to Stephen Valley Drive to be unnecessary at this time. With that said, the Department recommends approval of the request to eliminate conditions of approval 6A and B for case S10207, condition of approval 4A and B for case S10406, condition of approval 9A for case S10915, condition of approval 5A for case S11251, and condition of approval 3A for case S11349 that required construction of Powder Ridge Drive from the end of the existing paved road south of Nicoli Way, extending southward to the intersection with Stephen Valley Drive. Thank you.
Are there any questions of staff? Seeing none, we'll open the public hearing, and could we hear from the petitioner or the petitioner's representative, please?
Good evening, Madam Chair and board members. Thank you for taking the time to let Eklutna come in front of you. My name is Curtis McQueen. I'm the Chief Executive Officer of Eklutna. And standing next to me is Jim Arneson, our land manager. Also in the audience we have our design engineer and Triad and Dow engineer Tim Potter, who has been very involved in this project, so they may be able to answer some technical questions that we might not be able to answer throughout your questions. We also have in the audience our board of directors. Michael Curry, our president and chairman, A. Debbie Fullenwider, our vice president, Kim Zello, our treasurer, Lee Steffen, our corporate secretary, and Maria Coleman, our director. Just for a little bit of background, I'm going to make an attempt in a very short period of time to articulate Eklutna, as though, although I respectfully believe most of you know, we are the village corporation. We do represent the tribal folks from the native village of Eklutna. We are known for providing land to the community. It's in our past, we've had the community request our support in many developments, and including making land available. Not an easy thing for Alaska Natives to do, to cut land loose for development. However, we've taken a responsible path forward with working with many civic leaders, community leaders, and folks. We are known for Powder Ridge. We are very proud of that development. 30% of the occupants of Powder Ridge are the military community. We have had lots of requests to make more residential land available, and so we've engaged with Tim Potter of Dow over the last significant years to kind of master plan. The market is an ever-evolving animal, and so has a lot of various different interest groups, as was stated, with both the military and the railroad. We do our best to kind of guess and predict where we're going to be in 5, 10, 15 years, and we plan accordingly, but once in a while we have to reevaluate our position. It has been a very tough market, as most of you know, in the nation in housing and in Alaska, and we have worked very hard with the local banks and the local builders to be able to still keep some form of development going in Eagle River, and Powder Ridge, even in this tough time, we believe has been very successful. We have 2 ways in and 2 ways out. Jim Arneson is going to make some technical points of why we support not having the road built. I just wanted to kind of give a brief introduction on Eklutna. We are known for not just residential but commercial and industrial, and we still currently own 4 school sites where the schools are held. Chugach High School is one of the ones we own that is most well known, which the corporation does not charge or make money on. There are some significant parks that we've made available to the community, and what I'm trying to articulate is no disrespect to any other developers that may be in the room. We are a little bit unique in the way we look at development. We focus a lot on habitat. We focus a lot on green belts, and sometimes maybe even detrimental to our bottom line if we looked at it a different way. But saying that, I'll let Jim speak a little bit to our position tonight.
Thank you. Good evening, Madam Chair and board members. My name is Jim Arneson. I'm the corporate land manager for Eklutna. Hopefully this won't be as controversial as your last case, but this is an interesting situation. It's almost like a housekeeping issue. Many years ago, we had rosy glasses on, the economy was great, the military was talking about moving out perhaps, and there was going to be land available, and we were looking at 5,000 to 6,000 acres of military land to develop. So our planning had to include large roadways, and Powder Ridge Drive was one of them, but it would not have been the only one. We would have required more than one big road. 9/11 came along, and the negotiations that we had going on with the military ceased. All of a sudden, the big road wasn't as necessary as once we thought. But at the time, we were still looking at the railroad property, and we examined that up and down, and we determined that that property wasn't suitable for our needs either. It was too expensive to develop. It had a lot of wetlands. And so our grand plan for a great big Powder Ridge Drive evaporated. And before I forget, I'd like to reserve about 4 minutes of rebuttal time.
That gives you 1:43.
Pardon me?
That leaves you 1:43 now.
Okay, and there's 2 issues of concern here for us. One is we want to be able to provide a circulatory pattern for the entire subdivision. Right now we have about 99 lots being serviced by one road. The school bus does not go through the whole neighborhood. They stop and they go around up to Stefan Valley Drive and go back out. And so school children have to walk all the way up to Stefan Valley Drive. If we build out Phase 7, we'll have a circulatory pattern. The school bus can service the whole neighborhood. It'll make the fire marshal happy. And building Powder Ridge Drive, extending it, does not solve either one of those two important issues. So that's basically what our request is. We do not want to construct Powder Ridge Drive at this time because there is not a need for it like there was many years ago when we had different plans. And if anything should happen where development beyond Powder Ridge occurs and it occurs by us, we'd gladly build a road. We'd have to. But we just do not think that it's necessary at this time, and we request our petition be granted here tonight. Thank you.
Are there any questions for Mr. McQueen or Mr. Arneson? Thank you. Is there anyone else wishing to testify in case S11873-1, Powder Ridge subdivision?
Good evening, Madam Chair, members of the board. My name is Dan Page. I'm a homeowner in Powder Ridge. I've lived there for the last 6 years. I'm opposed to this petition. I believe the road needs to be built. The majority of the homeowners that live there with me agree with me. I don't know how many are going to testify. I'm a retired military guy, so I kind of think in a military decision-making manner. I'd like to start with a newspaper article that I pulled out of the paper from Saturday the 29th of May. A 4-year-old struck by vehicle and dies. A little girl in the Spenard neighborhood, and she darted out in front of a car and got run over. I don't want that to happen in my neighborhood. And right now, with the current structure that we have without this road, Conrad and Vasily are the main roads, and they're not designed for that kind of traffic. And so we've got plenty of children. Currently, with Phase 7, there'll be 300 units, 300 houses. It's about 600 cars. And right now, they're using mostly Conrad. They're not using Vasily. Phase 7 will use Vasily. I would ask any of you to come and watch the school bus on any given morning when the school kids are out there at the intersection that I live at Conrad, and there's no stop sign there, and the cars that are going to work just come zipping down the road. And it's a very dangerous situation. Military, looking at this thing, it's there's two courses of action: build the road, don't build the road. Advantages and disadvantages. I see advantages to building the road. I see very few disadvantages to not building the road. I'd like to identify the bottom line. The problem-solving, decision-making process is you've got to identify what the problem is, and I believe the problem here is money, and Eklutna is not willing to pay the money to develop the road. Mr. Arneson was talking about Phase 7 and that they're going to connect the road. They're going to do that anyway. Phase 7 will connect Rosser, and we're going to have the loop when they develop Phase 7. 2007, we stood in this very same forum before the Planning and Zoning Commission. The argument then was the design structure of Powder Ridge Drive and the specifics of the size of it. That body decided that they had to build the road. Now, 4 years later, we're back here debating whether we're going to build the road at all. And what's driving that is all of the units in Phase 5 and 6 have sold now, and Eklutna wants to develop Phase 7. They can't develop Phase 7 until they build Powder Ridge Drive per the outcome of that board. And they don't want to spend the money on that. They say it's an issue of money. And I think they've made a lot of money off of the 300 units that they've sold in there. I found it interesting that the Muni Traffic agreed with the petitioner, but yet in their verbiage they talked about all the problems that there were. The Alaska Department of Transportation did not agree. I saw the traffic analysis, and I think that's a bunch of, that's hard to understand for me. Looked like a bunch of strange things in there. And I just ran out of time. So once again, I would like to have the road built for safety. Thank you.
Are there any questions for Mr. Page?
Mr. Page?
Mr. Cole?
Sir.
Madam Chair, how does the road being built improve safety?
I'm sorry?
How does the road being built improve safety?
Because all of Phase 5, Mr. Arneson also said that most people would not use that road. I fully disagree. If you look at the map, everybody that lives in Phase 5 and 6 and the future Phase 7 would use the main road, the collector road. Right now, everybody in Phase 5 and Phase 6 come down Conrad. Granted that most of the people in Phase 3 and even Phase 1 and 2 are still going to use Conrad. Phase 1 and Phase 2 use Vasili. So really we're talking about all the houses back there in Phase 5 and 6 and 7, all of those units, which is about 140-ish. They would come in, the course of least resistance for them would be they would turn and get on the main collector road. And that would be about half the traffic, so that would alleviate a lot of the problem.
Any other questions, Mr. Page? Thank you.
Thank you.
Anyone else wishing to testify in case S11873-1 Powder Ridge?
Yes, my name is Michael Shannon. I'm an occupant of Powder Ridge subdivision. I live on Vasili, which is probably the main arterial road right now. It's the preferred road of use by contractors and contracting subcontractors because it's a straight in. They got one turn. When you go in on Baird Court to Conrad, which supposedly is a main road, a lot of the contractors won't use it, and trucks can't use it because they can't make the turn to come in or to come out. In the wintertime, Conrad is on such a steep of a grade. I think that there was a variance given to Eklutna to build that road because they couldn't get the homes on that road. Their driveways would be, over the 11-degree plane or something of this nature. So, I mean, half the time people are sliding through that intersection in the wintertime. If Powder Ridge Drive were put in, people would use Powder Ridge Drive. It's like my predecessor said here, the people in the back phases are using would be using Powder Ridge Drive. Right now they're using Vasili. I know a lot of people that come around because they're afraid to go down that hill in the wintertime. I mean, it's a big safety factor. And I don't know, the day after the 4th of July, it was nothing but truck after truck after truck, contractors and gravel trucks. And we still have almost 50 lots to be built in Phase 7, which is at the end of my street. And it's at the last meeting we had here, it was I can see this pattern going now. Well, if we get them to phase down the width of that street, if we get them to concede now, well, maybe we can get them to concede the road later on. And I see this being done. And this traffic, the last traffic analysis that was done, I don't know what year it was done. It was done when there was no construction going on. It was a dead time. Things just don't seem to be coinciding here, and it doesn't. I don't know how they can sit here and tell you that it's going to be done if Phase 7 goes in, and then they can turn around and come and petition you and rely on somebody else to tell you whether it is or isn't. And I'd like to know why there weren't more copies made available of the statistics, and everything in the back. There were 10 copies back there. We expected everybody from our subdivision to come, and they evidently just wanted somebody else to do the talking. You have more representatives from Eklutna here, and evidently they grabbed them all before we had a chance. But it would be nice if we had an advance copy, like Eklutna has an advance copy. I guess my time is up. Thank you very much.
Could you repeat your last name? I didn't catch
Michael
it.
Shannon, Shannon.
Are there any questions for Mr. Shannon?
Any more questions?
Thank you, Mr. Shannon.
Thank you, ma'am.
Anyone else wishing to testify?
Yeah, my name is Jack Brunner, and I'm a general contractor, and I live on Conrad Drive, and I built, I think it's an 18th house now in the subdivision, and I have nothing but good to say for Eklutna. They think for the best of the subdivision, all the builders, the buyers, and this construction traffic we hear about will cease shortly because we're filling the subdivision up. Maybe there's a couple dozen lots or so left in there, so another year that part will be over. The traffic increase will then subside to where we've got 2 roads to take what the engineers probably say is okay to handle. But if you put that 3rd road in the middle, there's only in one block, you've got 3 roads now going one direction. You're going to increase the traffic flow on Conrad Drive, using that for an example, upwards to 100%. If a vehicle off of Vasily and off of Conrad go over and take that middle road, the new Powder Ridge Drive, it increases it 100%. And then it goes down by that senior citizen area, which I think somebody should check. There may be a variance thing there that because it runs so close to the 10 or 12 senior citizen houses, and they're going to have an extremely fast road on both sides. It's going to increase the traffic flow. What we have now is going away. There's about 30 houses affected by this putting Powder Ridge Drive in. And them 30 people will lose value in their homes. And I know this because if I have a house for sale and it's on a busy highway, like the Glen Highway, you don't have as many customers for it. They don't like that noise. You get that noise in the middle of that subdivision, along with the Glen Highway, it will hurt everybody. Now, and it's true, we need to get that bus through and get these kids to school because they're trying to walk and they're little kids. It's cold, it's wintertime. I see that every day. They need access to school. If you have any questions to me, I'd gladly give you the very best answer I know how. And I once again say I think Clutton knows what they're doing. They really do try. They might not always be right, but we all fall under that category. Go ahead if you got any questions.
We have one question. Could you spell your last name, please?
Bronner, B-R-O-N-N-E-R, and I own Jack's Construction.
Are there any questions for Mr. Bronner? Thank you.
And what I'm telling you, I really is right. I mean, we don't need the road.
Anyone else wishing to testify in case S11873-1?
Good evening, Madam Chair, members of the board. My name is Trevor Edmondson. I'm the project development manager for the Peterson Group, and we currently are developing a project within the Powder Ridge development called Harmony, and it's a ranch-style townhome condominium development. It's located on Vasily Drive, and it's part of Phase 4 of the Powder Ridge development. Project's planned for 20 homes, 10 duplex-style buildings, and currently 11 have been sold in our development. The proposed road extension that Eklutna has asked to not build runs on the east side of our project, behind and adjacent to our project. So we are in support of Eklutna's request and feel like the existing requirements is not necessary because of the many changes to the development plans. Would the road extension would see very little traffic, as was indicated by the TIA, and the proposed road extension also puts extensive economic burdens on the developer with little benefit to the community. Would also make future Phase 7 economically difficult to develop because of the economic burdens of the road extension. So if plans change in the future, the road extension can be put in. But as it currently stands with the railroad and with the military, there's not a need for it. So, but it certainly in the future can be done when those changes to the plans are made and the proposed developer or the proposed projects come before the Platting Board and Planning and Zoning Commission in the future. we feel like the road extension of Vasily as a part of Phase 7, the future Phase 7, would provide adequate road access to the current master plan and would resolve the access issues for the school buses that have been talked about in the many public comments in the packet. So we would ask that you strongly consider Klutna's request and approve their request to not extend Powder Ridge Drive. So thank you, and take any questions you might have.
Any questions for Mr. Edmondson? Thank you. Anyone else wishing to testify in case S11873-1, Powder Ridge? Anyone at all? Would you care to use your 4 minutes of rebuttal time? Whoop, never mind. Hang on. We have someone coming.
Let him finish.
Go ahead.
Madam Chair and Board, I'm Dick Hamilton. I have, I think, was the earliest landowner in the Powder Ridge subdivision area. The piece of property we own, my brothers and I, was cut off by the Glen Highway. And we purchased this piece of property, and we purchased it, of course, with the intent of selling it at some time for a profit. And I don't think that that's such a bad thing. I think everybody in here that bought a house didn't have an idea of losing $200,000 per house on it. They bought it with an idea of selling it at a better price. Even our government and our IRS system promotes that. The concerns that we have a piece of property that is going to be affected by this, and it is going to put, when we develop, it is going to put that traffic on these two roads, Conrad Drive and Vasily Drive. I don't know if there's some other way of working this to where it would be advantageous for everyone, but I have a statement in here that I have basically made that said that road needs to be built. And over the years, we had a basic agreement at one time, I say an agreement, an understanding that we were going to build part of the road that went originally from Artillery Road back through into Powder Ridge, but that was later changed by Klutna. We have a piece of a property there in the corner, and it joins the Glen Highway. I don't know whether you can see it there or not, but the west portion of that property, probably 700 or 800 feet, the original road was put on that property and was to be split between E. Klutna and the property that Hamilton's owned. That was later changed. E. Klutna made a change to that, and then sometime later made another plan for an outlet mall, and then sometime later made the plan for Powder Ridge. And the thing that we have to look at is that when you're advertising something for sale and you have phases and you have plans and you have things that you're going to do, people are buying those houses and developers are developing based on those plans. So when we look at it, Hamilton's property there has been planning on Powder Ridge all along, and we haven't really done anything with it to date. But when we do, I don't want to, and I know anyone associated with me don't want to build 960 feet of road that's not on our property, which I think Title 21 brings about. So I think maybe you can see that to share in something, for example, maybe something could be done where if we end up with 15 lots, and I'm not saying I will do this,
Mr.
I'm
Hamilton,
saying there might be a possibility.
Your time is up, so you need to sum up.
Okay. If we ended up with 15 lots and Eklutna has 233, we might consider participating. But I have got to check on that. So until then, you can see that the development of this, if people are complaining about traffic now, then when we put 6.2 acres in there, I think they're going to complain more.
Any questions for Mr. Hamilton? Mr. Cole?
Through the chair. Mr. Hamilton, I'm not quite sure where you're talking about. Are you
where the property is?
Yeah, are you kind of south of the development?
Yes, there's a triangular piece that Conrad Drive, I believe it is, runs into. It's an open, vacant place. There's about 900 feet along the Glen Highway. And it's a triangular piece of about 6.2 acres. Now,
Is it kind of right in between the two developments?
yes. And, you know, we don't know what we're going to do. We don't know what we're going to arrange. We don't know what we could arrange with Eklutna or anybody else. But that land is there and it's going to be developed. And when it is, we don't feel like it would be a fair thing for us to pick up a road for 233 people and we end up with about 15 lots.
So, what is it you'd like to see happen? I'm not sure.
Well, I would like to see something work that works for Eklutna and for us both. And I really haven't had time to even talk to Eklutna. This thing has come up kind of quick. I flew in from Kenai tonight to make this meeting. But maybe we can do something. I don't know, but that's about all I can say at this time.
Thank you, sir.
Any other questions for Mr. Hamilton? Thank you, sir.
Thank you.
Anyone else wishing to testify? Okay.
Thank you, Madam Chair. First, I'd like to say we appreciate and respect everybody's comments. We certainly support the public process. A couple points. One of the comments talked about gravel trucks and a lot of activity after the holiday. Maybe just to clarify, outside of the development off North Eagle River exit, further down the road is a gravel operation. So that activity is going to happen unrelated to running in and out of that neighborhood. Also, the Powder Ridge Homeowners Association just recently voted to put speed bumps in the development, which we are thrilled about. We really support. So slowing traffic down has been something that we've been very proactive with as the corporation, including we've had issues with past law enforcement issues down at some dead ends where kids have been caught drifting with their cars on some old power line easements and so forth. So we've been very proactive with APD in not only trying to address that, but at significant expense of the corporation. We bring a lot of boulders and rocks and partitions to try to keep people out of the power line. A lot of people love that area and hike on Eklutna lands illegally, and we look the other way because we do support a lot of recreation. So we're pretty proud of that development. I don't know if Jim has something to add.
Yes, thank you. Yeah, I just wanted to make a polite comment about Hamilton's property. When Eklutna developed Phase 5, we provided road access all the way up to his property line. We provided water and sewer all the way up to his property line. So we've done quite a bit to provide improvements to his property, increase the value. And I understand that he'd like to make a profit and sell the property, and we have no issue with that whatsoever. but we cannot do everything for everyone else. Some stuff we have to do for ourselves. If you have any questions, technical questions, Dave Grenier or Tim Potter can answer other questions.
Any other questions? Did you have a question for Mr. Arneson?
The gentleman right here.
Okay.
Through Madam Chair. So when the original Powder Ridge Drive was proposed and made part of this development, was there anticipated development then going to be beyond Phase 7? Which,
yes,
as I understand, is not being developed right now.
Phase 7 is the last phase that has not been developed, and at that time we had considered extending Powder Ridge all the way to Artillery Road, and we would have received the land from the military on the west side of the Glen Highway there, and we would have put in a major development, and it would have it would have required an interchange halfway between north and south Eagle River exits as well.
So would it have been on the west side of Phase 7, or what I would consider the south end of Phase 7?
It'd be to the south and west, and almost those parcels, they kind of lie at an angle there, but it'd be to the south and west. And the railroad is more to the west, and the military is all west, and they have portions to the south.
Is there, with this being Powder Ridge Drive not being built, will there be sufficient roads for the development of Phase 7? Is that something that this plat board has to be concerned about?
When we did the traffic impact analysis, and maybe Tim Potter can expound on this, it showed that there would be enough roadway for Phase 7 without the extension of Powder Ridge Drive.
Is that using what's the name? Something Drive. Is that Facilia Drive?
Wasili Drive is on one side of the subdivision, and Conrad is on the other. And when you get into Phase 5 and 6, the road names change.
Okay. Thank you. That's all the questions.
Any other questions for Mr. Arneson or Mr. Potter? Mr. Story.
Through Madam Chair. I just go back to the agency comments, specifically the municipality traffic engineering and some of their concerns about safety. And you had mentioned that, have you installed traffic calming or safety humps or speed bumps or anything in the subdivision so far? Or would it be appropriate to have that as part of a condition of this request, is to provide or work with traffic engineering to provide that traffic calming device?
Madam Chair, members of the board, my name is Tim Potter with Dow HCAM, and while I wasn't involved in the original master plan, I've been involved ever since then trying to help clean up some of the issues that were done associated with that and bring the project forward. If I can digress just a hair, if you look at the master plan that I did hand out, there is a drawing. Although the roads are a little bit different and everything else, it does show that the original intent was that there was going to be an extension of Powder Ridge Drive that would go to the southwest and go out to and service the railroad property and the Fort Richardson property. So that does show that that's there, and that was the original intent. At this time, the findings and the traffic impact analysis indicate that the roads that are being proposed, and with the final Phase 7 completing the circulation loop, that the road network is going to be more than adequate to handle the traffic that's currently in that built-out subdivision. It's always interesting. I got involved in the redevelopment of Fairview and put in a lot of the traffic calming improvements there. Our firm wrote the guideline book for Anchorage for traffic calming. It's always interesting to me to listen to neighbors come out and bitch about their neighbors being the ones that are actually speeding and causing the problem. So whenever I go to the neighborhood meetings, I say, the problem is really easy to identify, and unfortunately it's all of you. So one of the things is they have to police their own areas, but as far as being able to put some traffic calming in, that would have a positive impact on travel speed in certain locations. That is very viable, and while I can't speak directly for Eklutna, I think it would not be a huge effort. We can meet with the neighbors and the homeowners association and do that. I will caution that as the city found out, as they did their traffic calming for speed humps and speed bumps in the neighborhoods, people would put in speed bumps, and it was usually the person that had the speed bump right in front of their house that would complain the most, because that's where most of the noise ended up occurring. So that was a disruption to them. So it's not a perfect science. It does need to be done as a whole and work with the network and the system. I believe that it could be addressed and we could make very positive improvements, and it would be up to Eklutna to step up. Obviously, since they are dedicated rights-of-way and municipal roads, that would have to be coordinated with the municipal traffic engineer, and we would not object to having that as a condition to resolve the need for additional traffic calming or traffic calming improvements coordinated with the city traffic engineer. Yeah, the other thing to note is that when the original Powder Ridge Drive was put into the master plan, it really did serve a different type of development, and thousands of acres to the southwest that would be incorporated all the way down to Artillery Road. And everyone saw that Artillery Road connection being the way to get people to an interchange to the highway without having them go to the North Eagle River access, and you could split the load and parallel the highway. As Mr. Hamilton indicated, there's been some history here, and I think that's the only reason anybody keeps me around anymore, because my gray hair, is that you need to recognize that after the original master plan, a significant portion, probably 30 or 40 acres of the east side of Powder Ridge Drive, down next to the North Eagle River access, where basically phase 3 and are, that was actually rezoned to commercial and B3, and that was going to be developed as an outlet mall, and it got all the way through site plan review at Planning and Zoning Commission. The rezone was approved by P&Z and the Assembly, and it was gung-ho. Eklutna got the property back from the developer because they folded. It was a Hawaiian developer, and after looking at the project in whole, it was determined that there really was a demand for single-family residential development, and they actually went back and modified the plan for that piece of property and developed it as single-family residential. So trip generation and traffic would have been much different. Additionally, Mr. Hamilton, because it's ironic that I'm standing here, because one of my assistants at the time, Tom Meehan, did the actual rezone to RO from R3 for Mr. Hamilton, and the significant support for that rezone was the fact that the adjacent property went to B3, and that the RO would be a transition development of density between the commercial and the lower density residential. So now it's interesting that the B3 went away, and now you've got this triangle on a steep hill with no access to the Glen Highway remaining out there. The good news is RO does allow single-family residential. It allows two-family and multifamily, so there could be an appropriate development there. It likely will not be office buildings or limited type of commercial as may be originally adopted and approved. So they have had it a long time. Their access was cut off by the Glen Highway construction. There is no access directly to the highway from that property. The road improvements have been developed to the property as well as sewer and water. So while the Hamiltons may not get the whole brass ring, they're going to get a pretty darn good brass ring because the improvements have been developed to their property, and they enjoy a lot of improvements, including access that they did not have before and they would have had to have paid for or sat around and waited for someone else to do it. So in a nutshell, the project's not what it originally was intended to be. The other very important thing to note is that the right-of-way, which is a very wide right-of-way, even for a collector road, because it had a super wide design, separated walkways on both sides with a tree-lined road. So there's an oversized right-of-way. That right-of-way has been dedicated and will be maintained. So it's not as if when the North Anchorage Land Agreement comes into play 20, 30, 50, 100 years from now, that there can't be a road. My fear is looking at the opportunities with Alaska Railroad and the military at this time with the Joint Base J-Bear coming in and Elmendorf taking basically over the whole thing, that it's a much more viable facility, and I don't see the Joint Base going away or shrinking anytime soon. And their mission is clear. They're not going to win a war by giving up land, and they're going to expand their training facilities out into this area, which they've already noted. And just to wrap up quickly, that I don't see the extension of that road being anything but a piece of pavement that will require everybody to spend money to maintain the road, push the snow off the road, and have the drainage affected to it, even though it won't be serving what it was originally intended to serve when it was first placed. So the security is there, the insurance is there, that the right-of-way is there when it's necessary, and the improvements are not necessary at this time.
So traffic calming devices are a possibility.
Pardon?
The question was traffic calming devices.
And Cluton indicated...
Wandered a little bit.
I apologize.
Through Madam Chair, I'm scared, but I got one more question. The traffic calming, we talked about that. One thing about traffic calming is to protect the pedestrians. And what do you have planned for pedestrian pathways or to keep the pedestrians off the roadways?
I'll talk about that.
Some of the streets have sidewalks on both sides. All the main roads have sidewalks, at least on one side. If the people do not use the sidewalks, I don't know what we can do about that.
Likewise, it should be noted that historically, even prior to any development, when the Cluton water pipeline and the power lines went through the property, that is used as a major trail corridor. Whether it's maintained that way or not, it is, by all accounts, a very busy and actively used trail corridor.
Thank you.
Any other questions?
I was just going to add that our biggest concern in recent years have been the wolves running through and all the habitat, rather not the cars.
Mr. Young.
Yes, Mr. Potter, maybe we can get a more concise answer this time, but with the traffic calming, I'm concerned about safety. If traffic calming were to be placed on, is it Conrad and Vasily, would that then necessitate the Powder Ridge Road to be extended or not?
No, what that would do, it does not decrease the ability of those roads to carry traffic. It would simply be designed to create and basically enforce a designed speed that would be lower. And there can also be things done at intersections and that where there's crossings to raise the awareness of the driver that there are pedestrians present or probably present and they need to wake up. Some of that can be with some noise strips, rumble strips is what they're called. Traffic speed humps can be put in and platforms, speed bumps can be placed. There can be additional chokers put into the roads where you'd actually modify the curb line and extend landscaping and or some columnar type things like bollards that actually shrink the visual width of the road, and that creates friction, which slows people down.
Thank you.
Any other questions for any of the assembled gentlemen? Thank you very much. So we'll close the public hearing. Are there any questions of staff? Seeing none, matter rests with the board, and could I have a positive motion in this case? Mr. Young.
Yes, in the matter of case S11873-1 Powder Ridge subdivision, I make a positive motion to approve the request to eliminate the following conditions of approval. Condition of approval 6, A and B for case S10207. Condition of approval 4, A and B for case S10406. Condition of approval 9, A for case S10915. Condition of approval 5A for case S11251, and condition of approval 3A for case S11349 that required construction of Powder Ridge Drive from the end of the existing paved road south of Nicole Way, extending south to the intersection with Stephen Valley Drive.
Did you want to add a condition about traffic calming or not?
No.
Okay. Is there a second? Ms. Moses, second. Mr. Young, would you speak to your motion, please?
I intend to support this motion from the testimony from the traffic department's analysis, from the information in our packet, from the testimony from the petitioner tonight. It appears that there will be adequate safety met without putting this road in, and that I do want to state that we did discuss traffic calming devices, and that's something that they can explore, but I'm not to mandate it. I'm not proposing to mandate that. And it appears from this testimony that there'll be adequate public safety here without this road.
Any other discussion? Mr.
Yes, Madam Chair, I would like to add the traffic calming. I think it's an important aspect of this case, and I think it's something that would be nice to add in here based on the comments that were provided to us. So,
would you make that motion then, please?
Yes, I move to add a condition B, to read, resolve the need for the coordination of traffic calming measures with the municipality traffic engineering.
Is there a second? Ms. McKenzie seconds. Mr. Story?
After the discussion and testimony, I feel that it's, I think they would probably do that anyways, but I think it adds to the case, and it adds to the approval of the case.
Any other discussion? Is there any objection to the motion? Seeing none, the motion is approved, and the amendment's approved, and we're now back to the main motion. So we have a motion to approve the request to eliminate conditions of approval with the condition that they resolve the need for traffic calming devices with the traffic engineer on the existing road. Is there any objection to the motion, the main motion, with its amendment? Seeing none, the motion passes, and the conditions are eliminated. One more. The next case is case S11452-4 Shangri-La East subdivision. May we have staff's presentation, please?
Yes, Madam Chair. My name is Francis McLaughlin. I'll be presenting Ms. Iverson's staff report. Some of the members of the board may not know me, so I just wanted to introduce myself. This is a second request for a 2-year time extension for the Shangri-La East subdivision agreement, and reviewing agencies have had no comment or no objection to the time extension request. 2 public comments were received indicating no objection. The department recommends approval of the second 2-year time extension to June 6, 2013. That recommendation is on page 3 of your packet. I'd be happy to answer any other questions you might have.
Any questions for Mr. McLaughlin? Seeing none, we'll open the public hearing, and could the petitioner or the petitioner's representative please come forward?
Madam Chairman, members of the board, I'm D. High. My consulting firm represents the petitioner in this matter. I guess maybe just to give you, not to take up a lot of time, but to give you a little bit brief history, in 2006, we have subdivision approval from this board with a condition placed on it that required a public-private section work together to get funding for the Mountain Air extension. That ended up taking several years to kind of accomplish, but we did accomplish it, and the funding for the Mountain Air extension has occurred. Of course, the 2008 economic downturn resulted in nothing really happening between 2008 and the latter part of 2009. Once the design and bid for the Mountain Air extension off our property looked like a reality, we put an effort into reviving this subdivision, and we currently have accomplished not only getting all our permits, we have our notice to proceed, and we're actually under construction. There was a technical issue with the fact of the timing that we didn't actually close out the first subdivision agreement. It stayed in place so that when we came back and asked for this first extension, it was granted, but there was a very short period of time left in it for us to accomplish the work. So we intend to complete the work. It's, like I say, it's under construction. We intend to complete it yet this fall with hopes of any leftover items to occur next fall. So we'd appreciate your support in granting the extension. Thanks. Any questions?
Any questions for Mr. High? I guess not.
Thank you.
Anyone else wishing to testify in case S11452-4 Shangri-La East subdivision? Anyone at all? Seeing none, Mr. High, you have 8 minutes left for rebuttal. Do you care to use any of that? He indicates not. So the matter rests with the board, and could the public hearing is closed. Public hearing is closed, and the matter rests with the board. So could I have a positive motion on this case, please? Mr. Story. Mr. Cole seconds. Mr. Story, would you speak to your motion, please?
Based on the staff's presentation, the petitioner's testimony, and the lack of comment and non-objection, I see no reason not to approve.
Any other discussion? Any objection to the motion? Seeing none, the motion passes and the second time extension is granted. Next case is case S11879-1 Markstrom subdivision. Can we have staff's presentation, please?
Thank you, Madam Chair. I'll be presenting for staff person Iverson on this case. This is a request to subdivide 3 lots into 1 lot with a variance from Anchorage Municipal Code 2180-300D to create a lot where the depth to width ratio exceeds 3:1, and the vacation of 5 easements as outlined in your staff packet. The purpose of this request is to dedicate right-of-way, vacate unnecessary easements, and replat the remnant parcels into 1 usable lot. The property is zoned B1A, and all lots are currently vacant. The surrounding properties are a mix of residential and commercial. The property is served by public water and sanitary sewer. Water main is located within Edward Street and DeBar Road. The sanitary sewer line runs through the alley to the north. The lot has the potential to have physical access to Edward Street. However, the municipality intends on selling the property to the owner of the adjacent apartment building to the west to mitigate the existing parking problem on that lot. Private development and traffic engineering have provided comments regarding access to Edward Street. The recommended condition of approval number 3 requires that a plat note be included that will ensure that any access onto Edward Street is built to municipal standard. I'd like to address the variance request at this time. The applicant has requested a variance from AMC 2180-300D to allow Track 3A to exceed the depth-width ratio of 3:1. Proposed depth of Track 3A is 290 feet, and the proposed width is 50 feet, resulting in a depth-to-width ratio of 5.8:1. Standard number 1, staff finds that this standard is met. The proposed right-of-way dedication and resulting dimensions of the tract is necessary to accommodate the construction of Edward Street that is already complete. This right-of-way taking is the physical condition that distinguishes it from other properties. This variance will combine what would otherwise be 2 remnant lots with little potential use into 1 usable lot. Standard number 2, this standard is met. The variance has no impact on the surrounding properties in the area. The tract has access to public water and sanitary sewer. By approving the variance, there will be no additional need for public services. Standard number 3, staff finds this standard to be met. Granting the variance will not have the effect of nullifying the intent and purpose of the subdivision regulations. The purpose of the depth-to-width ratio is to prevent development patterns that have physical access constraints or that otherwise result in an inefficient development pattern. The site has physical access and abuts right-of-way on 3 sides. Even though the tract will exceed the ratio due to the size of the combined area, it can be developed in a range of other uses allowed in the district. Standard number 4, staff finds this standard to be met. Undue hardship would result from the strict compliance with the subdivision regulations. The remnant lots will only total a sufficient area for a use if the lots are subdivided into 1 tract and the variance is granted. Without this replat of the remaining area into 1 tract, the remnant lots are too small to be put to good use. There is no other conforming alternative to this subdivision. I'd like to now address the vacation request. With regard to this vacation request, staff finds that this request appears to meet the municipal vacation policy and ordinance. Vacation of the right-of-way will not adversely affect traffic circulation. Given the dedication of right-of-way and this plat, this site is in need of easement relocations and the disposal of unnecessary easements. Generally, reviewing agencies had either no comment or no objection to these vacation requests. The Planning Division has no objection to the vacation of the easement, subject to recording a suitable plat. That said, staff recommends approval of the plat, variance request, and vacation request subject to the conditions as outlined on pages 8 and 9 of your staff packet. Thank you.
Thank you. Are there any questions of staff? Okay, we'll open the public hearing, and could we hear from the petitioner or the petitioner's representative, please?
Madam Chairman, members of the board, my name is Dan Baldwin. I'm with Lounsbury & Associates, representing the petitioner. Now, the purpose of this plat is to facilitate the sale of the property, and we have no plans to develop the property. With that in mind, I'd like to call your attention to the Department Recommendation 3B, submitting to the MOA Private Development section the site grading and drainage plan. As there is no development plan, we find that this requirement is unnecessary, and I would suggest rewording the condition to read resolving with private development the need to submit a site grading and drainage plan. And without a site grading and drainage plan, on condition 3F, there are a couple of notes there that reference the grading and drainage plan. And without such a plan, those two notes, I and II, are essentially meaningless. So those are the only two issues that I had an issue with. There were no objections to any of the other conditions. So, are there any other questions?
Any questions for Mr. Baldwin? I guess not. Thank you.
Okay.
You have a lot of time left for rebuttal. The guess is 8 minutes. Anyone else wishing to testify in case S11879-1 Markstrom subdivision? Anyone at all? Do you care to say anything else? Mr. Baldwin indicates not. So we'll close the public hearing, and the matter rests with the board. Are there any questions of staff? Seeing none, then I'll entertain a positive motion on the vacation request. Mr. Young.
In the matter of case S11879-1, Markstrom subdivision, I move for approval of vacation of the following easements subject to the recording of final plat within 18 months, and that would include conditions A through E on page 8.
Is there a second? Mr.
Sorry to interrupt. I just need a clarification. You said conditions A through E, and actually each of those are the easements that are being vacated.
Okay.
And I just wanted to have that clear on the record.
Okay, thank you. So item number 1, A through E. Thank you.
And Mr. Story seconds. Mr. Young, could you speak to your motion?
Yes, I intend to support this motion, and I find that all of the conditions are met for an easement, for a vacation request. That the conditions have been met for undue hardship, and that this would create an undue hardship if we didn't approve this.
Okay. Any other comments, any other discussion? Any objection to the motion? Seeing none, the motion passes and the vacations are approved. Moving on to the variance. Mr. Young?
Yes, in the case S11879-1 Markstrom subdivision, I move for approval of the variance from AMC 21.80.300D design standards, lot dimensions, depth to width ratio.
We need a clarification. Hold on.
Sorry to interrupt. On an earlier page, on page 6, where it lists the variance request, it clarifies that it's to allow track 3A to exceed the depth to width ratio 3 to 1 of 3 to 1. Does that need to be included in your motion? think staff could probably speak to that.
I don't think so.
That actually can be included.
But should,
It should be included, yes.
Okay.
Then in that manner, then I do wish to include that the variance would allow track 3A to exceed the depth to width ratio of 3 to 1.
And Mr. Story seconds. Mr. Young, would you speak to your motion?
Yes, I intend to support my motion. I believe that all of the conditions are met, and this appears to be straightforward.
Any other discussion?
since it's a variance, they need to make findings of with the standards for the variance on that.
You said it. You said the standards were met.
And you said the conditions on that.
Okay. Request has been made from the Secretary that you put a little more finding on the record that the standards have been met. For the granting of a variance.
Yes, the items number 1 through 4 on pages 6 and 7 are discuss the standards that have to be met, and the language here beyond it from provided by staff shows that those standards have been met, and they've also read those to us.
So you concur?
I concur, yes.
Any other discussion? Any objection to the motion? Seeing none, the motion passes and the variance is approved. Moving on to the plat. Mr. Young.
In the matter of case S11879-1, Markston subdivision, I move for approval of the plat for 18 months subject to the following conditions. A, I would like to modify B to resolve the need to submit a drainage plan for the need of drainage easements and drainage improvements. Item C, D, E, and under item F, remove I 1 and 2 and leave the remainder and leave G.
Is there a second? Ms. Moses seconds. Mr. Young, would you speak to your motion?
I intend to support my motion. Since this land is not proposed to be developed at this time and it's going to be sold, the need for drainage, for a drainage and grading plan is unnecessary, and the rest of the conditions proposed by staff seem appropriate for this property.
Any objection to the motion? Seeing none, the motion passes and the plat is approved for 18 months, subject to the amended conditions. We have just one more. You want to forge ahead or have a break? Forge ahead. Okay, last case on the agenda is case S11820-2 Uplands subdivision. May we have staff's presentation, please?
Madam Chair? Thank you. This is a request to subdivide one tract of land into 26 lots, one tract, and 3 green belts with a vacation of 4 easements. The vacations are supported by the municipal agencies. They're needed for the most efficient subdivision of the property. The department recommends approval of both the vacations and the plat, and the conditions are found on pages 12 through 14 of the packet. I'd be happy to answer any questions that you might have. The petitioner is also in the audience. On page 7, you can see that the Eagle River Community Council commented. They asked for a 30-foot wide natural vegetative buffer around the perimeter of the subdivision. There's nothing in code that supports that request. The department doesn't recommend that be added. The Community Council also asked that night-friendly sky, energy-efficient lighting to be used, and staff supports that, and staff has talked with the subdivider and the private development about how that would be done, and that's a condition of approval that you can see on page 12, condition number 3. There's also some concern from the neighborhood, the surrounding neighborhood, why the subdivision doesn't have a sort of a self-contained road system, why it connects to the existing road infrastructure, why there's not a road directly up from Eagle River Road into the subdivision, thereby relieving traffic on the neighborhoods to the east and the west. And the response to that is found on page 45 of the packet. Transportation planning speaks to that. Page 45 of the packet, you can see Vivian Underwood, senior transportation planner. She sort of speaks to the need to have efficient or integrated traffic circulation. Let's see. So again, on page 12, you can see the conditions of approval begin. Approval of the vacations, there are 4 of them. Approval of the preliminary plat for 18 months, subject to conditions 1 through 14. They're pretty standard conditions. Condition number 5 requires the subdivider to provide a site grading and drainage plan. 6 requires a groundwater hydrology analysis. Condition 7 requires an erosion and sediment control plan. 8 requires a stormwater pollution prevention plan. Going back a page on page 12, condition number 4 requires a 6-foot wide asphalt pathway detached from the road by a 7-foot wide green strip. That's not required by code, but the developer has offered that, gone over and above to provide that because they spoke with the municipal traffic department and the non-motorized transportation coordinator, otherwise known as the trails coordinator, and she thought that would be sort of a nice touch for this area. The last point that I'll make is just that, or comment that I'll make is that the developer, the petitioner, he originally came forward with, there's a history to this case. He came forward with a preliminary plat that requested several variances for depth to width, and for the length of a flagpole lot. And the reason for that is this is sort of a topographically challenged property, and there are huge tracts of sort of drainage ways and sort of wet areas. And so with all those sort of environmental constraints, the developer originally had some requests for variances. That sort of went nowhere, and the neighborhood was really not happy with the preliminary plat that was proposed. He withdrew that plat, that preliminary plat. It didn't come to the board, and he hired a different design team, and they came forward with a very different preliminary plat, and it's a much improved preliminary plat. So that's all I have. Thanks.
Any questions for staff? Seeing none, could we have the petitioner, please?
Madam Chairman, members of the board, my name is Tony Hoffman. I work with Land Tech, and we are representing the petitioner who's in the audience with us tonight, Scott Stewart, and Dave Grenier is the civil engineer on the project. We've worked with the municipality quite a bit on this project, trying to work out the details. For history, as staff noted, when we first got involved in this project, about 6 months ago, there was a design that had been the original application, which is if you notice there's a -2 on this, the reason is the -1, the design was I'm not going to say bad, it didn't work. And we took another look at it, and after looking at the municipal wetland or the drainage way mapping, the MOA, Watershed Management Service mapping, the original design had not taken into consideration any of those drainage ways. It hadn't taken into consideration really any of the topographic features of the property. So we took a step back, and there were quite a few flag lots on the other design. And in a site like this that's topographically challenged, those flag lots they don't work well. You get these long driveways, these 100-foot driveways, and you get a lot of grading involved. It starts chewing up the site. So we took a much more conventional approach to the design you see now on page 15, where we brought the houses into a more conventional design, and we dedicated the drainage ways, or we dedicated green belts around the municipally mapped drainage ways. So we've put aside almost all the issues of the original plat. We feel this design, it works well, it meets all the standards, we don't need any variances. We were able to eliminate all but 2 of the flag lots, and those are going to be 35-foot wide flags, so they work well, and they're actually quite nice lots with very, very, very nice views. So that's the history of the project. Now we did meet with the Eagle River Community Council, and had a very lengthy and open conversation with them, and I believe that we have satisfied most of their issues that we're able to satisfy. We do realize that they still have some issues with the traffic connectivity and such, but we are limited in what we can do on the site. The municipality is requiring us to create this interconnectivity that they're talking about between the 2 subdivisions. That's the municipal traffic department. And we basically are tied by this traffic connection. That's where we've come from on this project. I would like to make one comment on staff's comments on item 6. The way they've written this condition is resolve with private development the need for a groundwater hydrology analysis. Not that we need one, but that we need to resolve the need for it. So that's a distinction I want to make. It's in writing, and they've prepared it correctly, but Francis had just misspoke a little bit, and I just wanted to correct him on that for the record. Other than that, we do agree with all the staff conditions. We think it's well written, and we can live with anything that they've put on there. So I'd like to save the rest of my time for rebuttal, and if you have any questions.
Any questions for Mr. Hoffman? About 6.5 minutes left.
Okay.
Anyone else wishing to testify in case S11820-2 Upland Subdivision?
I'm thankful for your attendance here and paying attention, because my brain is gone at this point. I don't know how you do this all the time. My name is Pamela Weaver. I live on Lucas Avenue, and I have serious concerns about the proposal, basically because it has all the problems that you listened to for hours today. You listened to roads that were not finished to code. You listened to the municipality having to accept the costs for things that were not done, and things in Eagle River that have been done that you have not listened to yet today, but you have probably listened to in the past, or like the drainage at the tablelands that it was not properly done by the developers. And so I would like to start first about the Lucas Road connection. On page 5, it says that the municipality likes to connect their streets. They like the connection within a super subdivision, and that sounds good. However, the next statement takes all of the value of that away, and that is the street pattern in residential neighborhoods shall be planned in a form to discourage its use as corridors for traffic. And Lucas Avenue is written on this as being a 60-foot wide road. It is less than 30 foot right now, and it is not traditional asphalt road. It is designed to be a rural road, and therefore it was made with materials that were in a study, and therefore It's good for local traffic because there's very little of it. We don't have any sidewalks on Lucas. We don't have any drainage culverts. We don't have any curbs. We just have this rural type of surface road. We walk on it. We walk our dogs on it. Everybody uses it for rural uses. If the traffic goes through here, our lives will be changed completely in the entire area. All of the traffic will go to Wren Road, which is dead ends at the elementary school, creating a great problem. And so who is going to pay for sidewalks on Lucas? Who's going to pay for the curving and the stretching it out to be a 60-foot road when it's really less than 30? Who's going to take care of that? Well, it will be the municipality because the traffic will increase and it will be dangerous. And I have a question concerning the statement that, well, the road is too steep for it to exit onto Eagle River Road. I find that hard to believe since Stewart Avenue exits there and Pruce exits there. Pruce is very steep at the beginning, but at the bottom, if you look at this road, at the bottom, it's not steep there. The steepness is up here where they've already proposed a road. And if this is indeed steep, which I don't know, then it will be just like Pruce Road, unusable in the winter, which will increase traffic. So I have a lot of other concerns, but I guess my time is up. But Lucas is a bad choice to exit this road. Thank you.
Any questions for Ms. Weaver? Thank you.
Thanks.
Anyone else wishing to testify in case S11820-2, Upland Subdivision?
My name is Katie Justice. I live on Pruce, on the northwest corner of Pruce and David. We've lived there for 11 years, and I do also have some concerns about this subdivision. I appreciate the changes Mr. Stewart and the group have made. It's definitely in the right direction. But the traffic is the number one concern I have. Right now, there's presently 13 children under the age of 16 living on Pruce. There's only 12 houses on Pruce, so there's quite a few younger children that don't drive. They walk, they ride bicycles, and that's not including the parents, too. There aren't any sidewalks on Pruce. There are no street lights. That's one of the reasons we moved there, is because we like the rural atmosphere out there. The direct act, we're concerned because we've been told that the municipality will not let the subdivision have direct access on Eagle River Road. It's not that they like to connect neighborhoods. We were told at the community council meeting they're not allowed to put a connector road on Eagle River because it's not enough space between Stewart and Pruce. Now, I've not heard that tonight, but that's what we were told then. With 26 homes, you could have up to 50 more vehicles at least. That's just 2 vehicles, less than 2 vehicles per household, which is, I'm not an expert, but I know that's what I see in our neighborhood. That's a lot of traffic on Pruce. The road is not meant for that. It's not a strong road. The road is cracked. It's narrow. There is a lot of people walking and bicycle walking. On a hill that's steep on Pruce, school buses cannot drive up and down that hill. That is not, they're not allowed to take that because the hill's too steep in the wintertime. Often plows have problems getting up the hill, and they've a number of times take running starts to get up the hill. I know our last speaker talked about the traffic going out on Lucas, and they may do that, but they're going to learn real soon that you can't get out on Eagle River Road at Wren during school because of all the school traffic, so they're going to go down Pruce, and that, again, concerns me. I also want to encourage the requirement of the lights being sky-friendly to try to reduce the light pollution there. Again, my major concern is the traffic on Pruce, because that's where I live and that's where my children walk, ride their bicycles, and have to walk to get to school. And the additional traffic, I think, is a major hazard. I am concerned about that. Thank you. Any questions?
Any questions for Ms. Justice?
Thank you.
Thank you. Anyone else wishing to testify in case S11820-2?
Madam Chair, board members, my name is Mary Vitoni, and I am a resident on Eagle River Road. I live approximately 2 lots west of Pruce, so I'm at the bottom of the hill there. And I had a few concerns. My number one concern is the drainage, and I did read staff's report, and they did comment on that topic, but all water flows downhill, and I'm concerned that the changes in this area, in this undeveloped area, what will it do to my water supply? I'm currently on a well and septic, and then also, where will the water go? I mean, it's got to go somewhere. It's going to go down. Another concern I have is also the increased traffic. I raised 2 children living on that road, on Eagle River Road, and the speed limit increases from 45 miles an hour to 55 miles an hour right in front of this property. And living in that zone, it's a very busy street. So additional traffic there, and also the concern of the speed limit. Also, the concern that there is the roads, they're narrow, the streets are narrow, no sidewalks, so if you have additional people and kids walking to the bus stop is currently in front of my house, right in front of my driveway on Eagle River Road. So I'm thinking, where's the bus? The kids are going to have to walk down Pruce to get to the bus stop or walk on David. And another concern is just what is the impact going to be on existing homes there and their water and septic systems. Thanks for listening, and I hope you can consider those options when you're reviewing.
Any questions for Ms. Fatoni? Thank you. Anyone else wishing to testify in case S11820-2 Upland Subdivision?
Yes, my name is Glenn Justice, and I am a resident of 10126 Pruce Lane. I'm here as a private citizen and not in any capacity representing or acting in an official capacity for my employer. Having said that, I have one main concern, and that is the question about whether or not access can be gained to Eagle River Road. I understand traffic flow and those concerns, but to me, the transference of the safety issue with regard to access to Eagle River Road is being transferred to the subdivisions that adjoin this development. Personally, I have no other reservations about the development, but the concern of additional traffic in the neighborhood with the number of children that live on that street, some of the steepness of the road, those types of issues. There are a lot of people that bike in that neighborhood, walk their dogs, stroll through the neighborhood, and all of those people will be subject to additional traffic increases. The other issue that doesn't really concern me but might concern the municipality is the infiltration gallery from the impervious surface created by this development. There's already an issue with one property owner and his septic field, which may be a condition of the age of his septic, may be development upslope of this area, but an infiltration gallery, that water will not disappear a quarter-mile down gradient from Eagle River Road. I know that there is a groundwater discharge. This may increase that discharge. Not my concern, but the landowner, property owner, developer, homeowners down gradient from this area may be affected by the increase of water emptied into the groundwater. Thank you.
Any questions for Mr. Justice?
I just have one.
Mr. Cole.
Through the chair, I guess I'm just a little concerned. Where do you see the increased traffic coming from? Is it from the people that are living in this?
The residents, potential residents of that subdivision.
But won't they go primarily downhill to upper lowland and then out to Eagle River Road?
That's one scenario, but the other one would be that they probably feel closer to Eagle River. That's the issue. Would they feel that it's a shorter distance to Eagle River, which most of the traffic will head either to Eagle River to Anchorage? They may feel it's a shorter distance. down Lucas, and down Pruce.
So it would be like the lots that are close to Lucas might come, more people rather than going along the road would go up to Lucas and then down Pruce. That's the concern.
Right. And we already have young drivers that, shall I say, speed or drive up and down Pruce very rapidly at present. But, the increase in traffic, the potential is there.
Would it be solved by having?
Well, the solution, I see two solutions occurring with an access onto Eagle River Road. One is the two flagpole lots may be able to be redesigned and done away with, and the other is most everyone from that subdivision, in my mind, would then exit onto Eagle River Road rather than exit through the two subdivisions on either side. And unfortunately, you sometimes have blinders on when you see the lines on the paper that, there's potential for other things. So I would at least like to see the proposal made and included in the record. Hey, if you don't ask the question, the only answer is no. If you do answer the question, there are three possible outcomes. Yes, no, maybe with certain conditions. So I would like to see an official request made of either the municipality or the highway department, whichever, and an official response included in the record.
Yep. Okay, thank you.
You're welcome.
Any other questions for Mr. Justice? Anyone else wishing to testify in case S11820-2 Upland Subdivision?
Evening. My name is Rob Canetta, and I live at the southwest corner of the proposed subdivision on Pruce Lane. If you look at pages 16 and 17, the property that I own is basically the bottom of the drainage for the entire subdivision. Now, the developers have, looks like they're putting in some kind of a culvert to sort of direct the drainage from this entire subdivision away from our lot and out to Eagle River Road, but it is, I think, pretty evident at this point that this property is, and all the properties in this area are in a very delicate balance as far as groundwater and drainage are concerned. Our well has already failed once, and we've had to replace the pump due to sand being injected into it. We've had our septic is failing due to groundwater coming up, so that when they pump out our septic tank, the water comes in through the leach field, and we're very concerned about what's going to happen next year, 2-3 years down the road, to our well, our septic, and others in the surrounding areas from this development. The Heritage Subdivision north of this property had set up a fund to take care of the people downstream, and it's already been put into play by other residents in this area that have had issues with drainage, flooding, and so forth. And so I just, would really like to appeal to you folks to think very carefully about what's going to happen to the groundwater and the drainage in this area. There's a lot of talk about submitting hydrology studies and items 5 through 9, 14, B, and C. I mean, they all talk about things that need to be done. Are these things going to be done before it's approved, or are they just going to be, I can't find any information about what's going to happen. The preliminary study that we saw last fall showed the runoff almost doubling due to this development. So, we have a lot of concerns about well failures, septic failures, and so forth. So I just hope that, us showing you folks that we are very concerned about this, as well as the traffic and other issues. But this is, our main concern is because we're at the bottom of the whole drainage scenario. So, thank you.
Mr. Kaneta, could you spell your last name?
It's Kaneta. And we're at 10023 Pruce. It's right at the bottom of the hill.
Any questions for Mr. Kaneta? Mr. Young.
Yes, through the chair, Mr. Knet, if you're at the bottom of the drainage and they're having a culvert divert the water away from your property, how do you perceive that's going to impact your well and your septic system?
Well, what I'm trying to say is that the entire area is very delicate, and they're talking about putting a culvert in, but if you look on page 16, the culvert does not extend even to the point where the bold dotted line indicated by the municipality of where the water drains onto our property. I mean, I don't even see the water hitting that culvert until after it passes it. I mean, it's not even hitting it at all. So I would at least like to see that culvert, extended up to where the water is shown by the municipality to pass into our property. I mean, I just want to make sure that, well, if this goes through, that, we aren't, looking at a flooding situation.
Thank you.
Thank you.
Any other questions, Mr. Kaneta?
Thank you very much.
Wait,
Yes,
one
sir.
more.
Just for clarification,
Yes.
you're in Lot 1 on the corner of Spruce and Eagle River Road?
Yes. In fact, our property on page 17, you can see our property at the bottom of page 17. That's our house right there. Okay.
Thank you.
Thank you.
Anyone else wishing to testify?
My name is Paul Forward. We live on the very east end of Lucas Ave, right immediately adjacent to the proposed development. And I've got just a couple of comments. The Eagle River Valley Community Council meeting that we held addressing this issue was very well attended, and a lot of the discussion pertained to safety issues, neighborhood safety issues, as you heard from some of the previous speakers. A lot of that is the roading coming out on our roads not designed for the traffic that we're anticipating. Pruce, for instance, is not even an option for winter. It's a very steep road going to Eagle River. It's got another road, David, coming in right at the peak. Very dangerous. People don't use that, but we don't use it much in the winter either. But folks have to use it on Pruce, of course. But limited traffic is probably okay. The other way to go is down Lucas, where I live, to Wren. And Wren it had a tremendous increased traffic from Heritage Estates subdivision, and now we have a lot of accidents happening on Wren, and coupling with that is the Ravenwood School comes right out on Eagle River Road, right where Wren intersects, which would make also much of a concern. And Mr. Cole mentioned the traffic might be going downslope, but with the new cul-de-sac plan, it looks to us like we're going to get most of the traffic in our area. My main concern here, big issue to me, is the planning aspects. And for consideration of the Platting Board and the municipality is the lack of or a need for an overall plan, we feel, for the property. This phase you're looking at, you're going to approve or not approve, is tonight should consider a future plan, which is a plan. There is property on Eagle River Road. There's going to be several homes there in the future, 5, 10, 20 years, but there will be. I'm a forester, I think, long term. But so they're going to either have driveways going out on Eagle River, or there'll be a road on that last development phase. We think that road should be looked at now. That could perhaps alleviate the safety hazards in our neighborhoods. And when that road's put in, if that was designed now, that could serve, it probably will be a road rather than driveways, it could serve those homes. Maybe a connect could go up into this development if it's done now, but that will be forever lost if it's not, if the plan now, if you don't plan for that now, the houses are going to loop around. There is going to be no opportunity after this development is done for a potential connect, which would be good for everyone. If that, I've looked at the slope and I've got a topo map, and I know it's got a very nice entrance from Eagle River Road where the drainage is very smooth, flat, but it does get some steep like Pruce. But there's another area within the subdivision that's also very steep that's planned, and so we feel at least be looked at. At least that should be looked at. I don't know. I think I'm for everything. It's everything we need to do it, and that's my comment. If that could just be looked at before it's decided, we would perhaps could address the safety issues. And lastly, I certainly agree with the fund, the Heritage State. I'm out of time. The fund needed to alleviate a lot of anxiety for folks, and thanks to. Just wanted to thank the engineers here too for a really good plan and a thought to leave a few trees if hopefully we can at the entranceway. I sure appreciate that. Hopefully it might happen. Thanks so much.
Any questions for Mr. Forward?
I guess since I still don't understand where the road could go in that would make it safer onto Eagle River.
Right.
Isn't it too steep if you went from Eagle River straight up into that?
Our thinking is that if a road, when they do the final, whatever that is, the road, they've got to have a road to access for the homes that will be eventually built there. If that road were planned now, there could be a connect going up. It would alleviate the traffic from going into the neighborhoods. As you've heard from people here, we've discussed what the roads are. They're narrow, they're not lighted, there's no sidewalks, there's older people like myself, there's school kids. The buses aren't even allowed to go down Pruce. They're just not allowed to for steepness. And so this would provide another option for winter especially to get out. We think a lot of the people might go that way and not go in the neighborhood. It wouldn't be I wouldn't think it'd be a very costly thing to put a little link there. It just needs to be looked at, I think. I'm not an engineer. But that would be something, hopefully, that could just be considered. That's it. Thanks. Done.
Mr. Forward. Thank you.
Madam Chairman, members of the board, Richard Radcliffe. I live on Pruce Lane, Lot 7. My first concerns are long dated. They have to do with the development upstream of us, mainly our well and septic, because if you look on both sides of this proposed subdivision, these subdivisions are on well and septic. This subdivision would be unique in that it will not be on well and septic. Heritage Estates, we had some issues. Drainage also, the effect on the aquifer, recharging of the aquifer for our wells. I have also gone through one well and a pump. My neighbors have gone through 4 pumps, and downstream you heard from Rob, he had problems with his wells also. So I think it might be appropriate at this time to suggest something, maybe a fund or a guarantee, because, you know, we're retired, Paul's retired, and any development is going to impact us. The road system, yes, it will impact us. And there is already an existing access road, municipality service road, that is open year-round. And it comes off Stewart Drive, and it goes right down to Lucas. That's an existing, in-place, serviceable road. There is a road into the subdivision already. And if you look at the subdivision, you need glasses, but anyway, if the utilities were brought into the subdivision from Eagle River Road, it could exit through into Stewart Drive. So you would have your connectivity that you're talking about in your subdivision. This also would provide utilities to come up to a main artery and feed your existing plat. So this would alleviate the issues that us residents are trying to express to you right now. And these are real issues. As we have experienced living here for 20 years or whatever, we have seen development and we've had issues. And one of those is the traffic. And Wren going to Ravenwood, which are young families with kids. So these are concerns that I don't think have been addressed. This is an easy way for Mr. Stewart is getting quite a deal here. He's getting the sewer run down half a mile to his property. He's getting all the easements, electrical, gas. These are all bending toward his wishes for this subdivision. This is what I don't understand. This is all in favor of the developer and no concerns for the existing subdivisions, their quality of life, and their threatened systems, which would be their well and septic, because we don't have sewer, we don't have water available to us without a cost, and we know what those costs can be. They can be very expensive. For retired people, they can be almost insurmountable. So I would ask you to take another look at this proposal. I don't have a problem with the development per se. I do have a problem with the access. And I do have issues with well and septic, which everybody, both sides of the subdivision, will have an issue. And if it does come to bear that we do have problems, where do we go? What are our options? As planning and zoning,
Mr. Radcliffe,
I would hope that,
just sum it up.
yes, I would hope that you would have something to say there. So to sum it up, my issues are, of course, primary well and septic. Those are the big costs for any homeowner in the area. The buffer zone, that is negligible, so that won't count. As far as future development, like I pointed out, if the utilities are brought in central to this piece of property, I think it would serve the development of this property in the future, because there will be more development. I have no doubt about it. So thank you for listening. That's all I have to say.
Any questions for Mr. Radcliffe? Ms. Moses.
Through the chair. Sir, you mentioned, do you have the option to connect to public water and sewer upon payment of an assessment or something in that area?
We have no option. The sewer is a half mile away.
Okay.
Who can afford that?
Well,
What private property owner could afford that? Nobody.
Thank you.
I don't, do you understand my position, though?
Yeah.
I'm trying to let you know that I'm not the only one concerned about this.
Thank you. Any other
Nothing?
wishing to testify?
All right.
I'm Melody Radcliffe. I also live on on Pruce for lot number 7. I am very grateful that I live in Eagle River because I'm surrounded by very intelligent, smart people, and 75 of them showed up at the first meeting that we had about the subdivision in August, many of whom were from the latest development from the Stewart subdivision. They had bought the houses and they had come to the meeting because they had several concerns, some of which were the clear cutting of the lots. One of the people built their own house and they were able to leave trees. It looked very nice. Everybody else's lot was clear cut, and that's going to cause problems with the water. I was not able to make the June meeting, and unlike Tony's perception of the meeting, what I heard was that they did a very good presentation, that things had improved a lot, but there were many concerns that we did not have time to address at that meeting. So I'm here to ask you for more time, and since you're requiring the numerous reports anyway, I would hope that we could postpone this until those come in. I'm concerned because there have been heavy equipment on the lot already. They went and cut the trees down all the way up the valley there, all the way up the tract already. They've had surveyors in there. I'm not sure what the rules around that are, but things are going forward without the permitting process being done. I am concerned about my well and septic. I raised 2 children there. It was a safe neighborhood. I, however, have slid through the Pruce intersection several times. My daughter ended up in the ditch, so if people try to go that way, it's not a good thing. Some of the development that has taken place up there was less than wonderful. One lady has a retaining wall right next to her window, so I'm just concerned about the quality of the development. I am pleased that there have been so many improvements, and I just would again like to reiterate that I would like the community to have more time to discuss the concerns and have them brought forward in the manner that is customary, where we go through our community council and they put forward our concerns in writing for you, so you can consider all of the facts. I'm a teacher in Eagle River. I plan to stay there for a long time. We've been there for 20 years. I love my neighborhood and I don't want to have to move. And I'm going to be retiring soon, as well as my husband, so those costs for hooking up to well and septic, if our well fails, will be significant. And when we first moved into the house, we had a 600-gallon holding tank for water because our well had to be redrilled before we were there. I know 4 other people in the neighborhood who've had on their second wells. So because it was an issue with Heritage Estates, they did have a fund set up, and so they have not had issues right now. If we could have something like that, that would be awesome, because we can't afford $300 a foot to hook up to sewer and water. Thank you for your time.
Any questions for Ms. Radcliffe? Thank you. Anyone else wishing to testify?
My name is Donna Forward, and I live at 20745 Lucas Avenue, which is Lot 10, adjacent to the subdivision. I really had not planned on speaking tonight, but I accessed the staff notes today on the Internet before I came in, and there were a few things that I'm just really puzzled about that I hope might be considered tonight. First of all, one of the comments that was made this evening said that while the community council requested a buffer around the neighborhood to preserve the integrity of the existing neighborhood, I thought I understood, and from the paper that I accessed, it says the surrounding neighborhood is the same R1A zoning as the proposed subdivision. And while this is true, we are an R1A subdivision, I think that you certainly understand that R1A built in 1980s is a little bit different than R1A built in 2011. As you've heard, we do not have wide driveway or wide streets. We do not have lights. We do not have the sidewalks and all of those things. I find it difficult to hear people on staff say that we are the same neighborhood zoning-wise. Yes, we are, but we are rural, and this new subdivision will not be. Another concern that I had was that under right-of-way comments, letter F says, the drainage appears to flow to the southwest corner and then into the adjacent subdivision with no apparent permissions and drainage easement. Now, I'm not an engineer with engineering background. I have not been able to understand that was addressed in the comments that followed. Mr. Kaneda lives at that southwest corner, and it says in this paper that the drainage appears to flow to the southwest corner and then into the adjacent subdivision with no apparent permissions and drainage easement. So that is a big question for me. The other thing that I didn't understand was that I thought the staff, with their engineers and all, had background that would investigate certain aspects that had been presented by the proposed subdivision. This one statement doesn't seem very scientifically based to me. The proposed street pattern is a natural continuation of the roads in the adjacent subdivisions. Staff understands that due to the steepness of the grade, that alternative connections to either Stewart Drive or Eagle River Road are not feasible. Staff understands. I'm not understanding, and I did hear the bell, I'm not understanding why it was not addressed beyond we understand. Is it scientifically a possibility? Is the steepness scientifically shown, or is it shown on a plan, a map, or something? Or do we just understand it? That doesn't seem responsible in addressing the concern. Thank you. Any questions?
Questions from Ms. Forward? Thank you. Anyone else wishing to testify in case S11820-2, Upland Subdivision? Anyone at all? Mr. Hoffman, you have
Can we put this up?
6 minutes and 22 seconds. Oh,
Overhead?
you turn on, Elmo, hang on, we're getting there.
She knows.
Maybe?
I know. You do this every time.
What's this button down here? You can turn it on, turn it off. Okay. No? Oh.
The base won't turn on. Either one of them will. Well, we don't have to do it this way, I guess. Is there another step? Nope. It's magic. Okay. First of all, what we want to address the traffic issue and put this. We do understand that the neighbors want an access directly onto Eagle River Road. To build that road, first of all, to municipal standards is not feasible. While Pruce is not built to municipal standards by the current standards, we wouldn't be allowed that same luxury. So it's not engineering viable. The other issue is if we build anywhere across there, we're going to be destroying these drainage ways. And part of the whole concept here is to we have one crossing of the drainage ways. We're trying to preserve those. The other point about this interconnectivity is the municipality of Anchorage is requiring this interconnectivity for fire safety and their standards. There's no way around that. They're not going to allow a dead-end street in the subdivision to be here. They're not going to allow another dead-end road here. It's just not going to happen. The traffic department has required this connectivity. So our hands are tied, and it's good design process. It's good for fire safety, for fire evacuation. If something happens here, these people all have secondary accesses. Now the other issue, all 26 homes are not going to exit out this way. The logical nexus and traffic studies show most likely people are going to go downhill. So at least half of the people are going to come out this way. Everybody goes downhill. I mean, that's the way they're going to go out to work. That's the way they're going to go. They're not going to turn right and go up the hill and around and then back down a very steep road. Upper Lowland is built to a newer standard, and it's a wider road, and it's a newer road than Pruce. Pruce is in bad shape. It's a steep road, and there are icing conditions. We recognize that. But all these people aren't going to come out here. The logical nexus is right here. These people may come up and around. That makes sense. But these people coming out of the cul-de-sac, they're going to go downhill. That's what the traffic studies show. So our hands are tied with this connectivity. And building a road out into Eagle River Road is just, it's not engineering. It's not good engineering. And adding 26 cars to another driveway on Eagle River Road is not a good idea either. And we would have trouble getting a DOT permit for that kind of a driveway. I don't know if we could, because you have less than 1,300 feet well less than 1,300 feet between these driveways, and, you know, DOT standards, and I'm sure some of the staff or board knows that, we'd have trouble getting a driveway permit. So it's just, and regarding future development plans, there are no future plans on the table. When if and when anything happens to this tract, the public will have a whole nother shot at this, and we'll have to deal with all the driveway issues and any other applicable municipal codes at that time. So we don't know what the plan is there with the new Title 21. We don't even want to think about it. And right now, Mrs. Stewart lives here in a house, and this is where she lives. So right now, there's no plan to do anything with that. She doesn't have any intention to move. I can tell you that. So the other thing I wanted to talk about is, the utilities. Now, there's a lot of talk about the utilities. The utilities are not being provided in the subdivision. We have to bring in water and sewer into the subdivision at great cost to this development. That it's not given to us. So, however, the water and sewer, this zoning is 15,000 square foot lots minimum with water and sewer right now, and that's the way it's set up. These are big lots. Now, the water and sewer is not easy. It's going to be very expensive infrastructure. So the developer is not being given water and sewer, as was earlier stated. So those are the things I just wanted to point out, and I do believe that this design has addressed those. Now, Mr. Grenier wanted to talk a little bit about the drainage and talk about what's going to happen on the post-development.
Yes, I'm Dave Grenier, Triad Engineering. The drainage on this project is basically what we're trying to do and will accomplish as part of the conditions is no net increase in runoff. In other words, what runs off the site now will be what runs off at the end. And the way that will be accomplished is we're retaining the drainage ways that are marked, are mapped by the municipality. They will stay in place. They are in open space green tracts. They will stay undisturbed. Those areas will have an infiltration gallery which will slowly allow the water to perk into the ground. The outfall that occurs now does go across Lot 1. The culvert that was mentioned earlier by the resident, the water will be directed through that culvert. Right now it runs across his lot in this fashion. So we are eliminating the existing situation now. We're solving that drainage issue that he has. So with infiltration and a maximum a net no increase in runoff, we feel we're addressing the drainage. With that, I think we'll answer any questions. Thank you.
Or Mr. Grenier? I guess not.
Thank you.
Okay, we're done with it.
And with that, we'll close the public hearing, and the matter rests with the board. Could I have a positive motion, please, on the vacation requests? Mr. Young.
In the matter of case S11820-2, Upland Subdivision, I move for approval of the vacation of the following easements subject to recording of a final plat within 18 months. Number 1, 60-foot wide drainage easement. Number 2, 20-foot wide gas line easement recorded book 2133, page 692. Number 3, 10-foot wide electrical easement recorded book 2180, page 675. And 4, 60-foot wide water line easement recorded in book 2133, page 692.
Mr. Cole seconds. Could you speak to your motion?
Yes, I intend to support this motion. From the presentation tonight, these appear to meet all the requirements by the municipality. The municipality has reviewed these and is supporting these, and I believe they're prudent, and I'm going to support them also.
Any other discussion on vacation of the easements? Any objection? Seeing none, the motion passes and the vacation of easements is approved. Moving on to the plat. Mr. Young?
In the matter of case S11820-2, Upland Subdivision, I move for approval of the preliminary plat for 18 months, subject to the following conditions, and that would be items number 1 through 13 on pages 12 and 13.
There's one on 14.
And also the conditions on page 14, including number 14 on page 14.
Mr. Cole seconds. Mr. Young, would you speak to your motion?
Yes, I intend to support this motion. I believe that from the testimony tonight, there's been a lot of discussion about traffic, and the surrounding community is asking for something that is not feasible. The municipality is requiring a traffic pattern with connectivity for the other subdivisions, and this meets those needs. The issue of drainage has been considered. There's developers testified there'll be no net increase in runoff, and the one off-site lot that has problems will have a culvert to bypass that, eliminating those problems. There's been questions about wells running out of water, and these conditions address that by providing to watershed management services an acceptable stormwater pollution prevention plan, an erosion sediment control plan, and number 6, resolve with private development the need for groundwater hydrology analysis to determine the seasonal high groundwater elevation and the need for footing drains. So the water issues are required in this, within this motion.
Any other discussion? Any objection to the motion? Seeing none, the motion passes and the plat is approved for 18 months, subject to the conditions listed on pages 12 through 14. That's the end of new business. There's no items listed under appearance requests, no persons to be heard, no reports. Any board member comments? Entertain a motion to adjourn. Mr. Young.
So moved.
Ms. McKenzie seconds. We are adjourned.